The meeting of the Michigan Board of State Canvassers for July 24th is called to order. Good morning, everybody, and good morning to everybody in the overflow room. It's great to see everybody this morning. Thank you all for participating in today's meeting. If my voice is too low, will you flag me? Before we get into the meeting this morning, I wanted to give you kind of an idea of where we're going. We have a really heavy agenda. If you've read it, you know that. Some large issues, some long issues. We have a lot of people here who are interested in what we're doing. We care about all of you, but public comment is toward the tail of the agenda. And so the way we're going to proceed this morning is we're going to go item by item. The people who will be invited up to the podium will be the people who are the representatives of the issues that are being discussed, the legal representatives, the appointed representatives. We'll get all the issues out of the way, and then we will have public comment, and I think it'll be a pretty smooth meeting. Just straightforward. Good. That said, I would like a consideration of the meeting minutes for the June 5th, 2026 meeting.
Move to approve. Second.
It's been moved and seconded. All in favor? Aye.
Aye.
Item 2 is the consideration of the sufficiency of the recall petition submitted by Ashley Arita against Victoria Bishop. Director Brader, would you read the reasons for the recall?
Yes, the reasons for recall printed on the petition are: on June 12th, 2026, the Michigan Bureau of Elections suspended Victoria Bishop's access to the state's qualified voter file, QVF, stating that her actions fell outside the scope of her statutory authority.
Thank you, sir.
Could I just add quickly on that, Chair Housecamp? So with this process, obviously this recall petition this language does implicate action by the Bureau of Elections. I just want to note that under section 951A of the election law, the Board of State Canvassers is determining the sufficiency and factual and clarity determination for this. The Bureau of Elections never makes a recommendation to the board as to whether recall language meets those requirements. We provide past examples, but that's it. So we're not going to make any recommendation here, but that's not because it relates to the Bureau of Elections. It's just that generally we never make those types of recommendations.
Thank you, sir. We have two folks here speaking as part of this petition. We have the recall sponsor, Ashley Arita. Are you here? Yes, ma'am. If you'd come up, I'm going to need you to do a couple things. You are not an attorney, is that correct? Okay, I need you to first turn on your microphone. It's the small button at the base of the mic. You'll know it's successful when the little red light comes on. There you go.
Good morning.
Good morning. So the first thing I would like to do is to swear you in. Since you're not an attorney, I'm going to ask you to raise your right hand. You solemnly swear that the testimony you're about to give this morning is the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you. Now, would you state your name and spell it for the recorder?
Sure. My name is Ashley Arita, Areeda.
And go ahead.
Sure. Thank you. Thank you for having me. I am here on behalf of the committee to recall Victoria Bishop. We are here because the language of this petition is factual, clear, and understandable in plain English. It states that on June 12, 2026, the Michigan Bureau of Elections suspended Antrim County Clerk Victoria Bishop's access to the qualified voter file, stating that her actions fell outside the scope of her statutory authority. The opposition asks this board to remove her actions out of the sentence to pretend the petition describes only what the Bureau did and says nothing about Victoria Bishop's conduct. But those words are there. They identify whose conduct caused the state's response, the official consequence of that conduct, and the exact date that consequence occurred. Michigan voters do not need a law degree to understand a complete sentence. The legal question before this board is not whether Victoria Bishop should ultimately be recalled. Her own rebuttal submission acknowledges that the truth of this recall is reserved for the electors. The question is whether voters can identify the course of conduct at issue, and they plainly can. Our committee is not a political machine. We are ordinary Antrim County residents made up of Republicans, Democrats, Independents. We're neighbors, organizing at kitchen tables and in community rooms and all across township lines. We have given our time because protecting elections cannot be left only to institutions or political insiders. At a moment when election workers, election systems, and public confidence are under attack across our country, accountability is not a threat to democracy. Accountability is how democracy defends itself. The qualified voter file is not a political tool. It is part of the public infrastructure of our elections. And when an elected official whether access is suspended because the state says her actions exceeded her statutory authority, voters have a right to decide whether she should remain entrusted in that office. We're not asking this board, again, to recall Victoria Bishop. We're just asking that you do not take that decision away from voters, from the people of Antrim County. Please approve the petition language. Let the citizens organize, let the voters hear the facts, and let the people decide. Thank you.
Thank you. Questions? Thank you, Fris. We have Kevin Kiewski. Mr. Kiewski. Would you state your name and spell it for the recorder?
And good morning, Kevin Kiewski here on behalf of Victoria Bishop, the clerk of Antrim County. Thank you very much, Mr. Chairman. In addition to members of the board, you have our submission and exhibits. I know you have a very busy agenda, so I'm actually looking forward to seeing what happens after this. But I'm going to leave you really with just some brief highlights in addition to a proposed motion I would recommend that the board make after hearing our arguments today. So every reason for a recall must be a factual statement of the officer's own conduct, clear enough for the electors to identify what she did. This petition never says what Clerk Bishop did, not one act, not one date, not one word of her conduct. In the petition's one sentence, the only actor is the Bureau of Elections. The Bureau suspended access. Clerk Bishop appears 3 times, but each time as a possessive, her access, her actions, in addition to her authority. She is never the actor, not once. Everything else is the Bureau's opinion about unnamed actions. So let me tell you 3 things we're not asking you to do. We're not asking you to judge the truth because the Constitution actually says that belongs to the voters. We're not asking for detail because if you take a look at the Whitmer case, the recall cases, the board approved and the Court of Appeals upheld 9 words, quote, signed Executive Order 2020-11 on March 16th, 2020, end quote. And we're not asking you to tighten this standard at all because review is lenient and I accept that as a matter of law. But the thing is that we have to realize is that every one of those rules is about how much a petition must say about the officer's conduct. Leniency can forgive a thin description of an act, but it cannot supply an act the petition never states. For a century, Michigan rule and law has been very consistent on this. Taking a look at 1926, Newberg versus Donnelly. A recall must rest on, quote, some act or failure to act, end quote, of the officer. All 19 reasons this board approved on the Bureau's own list of 2019 through 2023, which we have as Exhibit 1, they fit that pattern. Page 2 of our submission lays them beside this petition. Officers are acting on the left, if you take a look at page 2. Also on page 2, what do you see? Our particular case. The officer is acted upon on the right. And this panel has already applied this standard unanimously. You could take a look at March 14th, 2025, as you see highlighted in Exhibit 2. A reason where the Secretary of State was the actor, but it was still rejected. Why? Because of one term, quote, far longer, end quote, was unclear. And a second, the same day, rejected for a lack of a date. And Exhibit 3 as well, I'm not going to go through all that, but it adds more of the same from January 2024. No date, and there was an opinion offered instead of a fact. So this particular petition in front of you actually has a whole bunch of defects. There's no date, there's no content, and actually goes even further in terms of how deficient it is. It never names her as the actor at all. If those failed, this cannot pass. We're just asking for you to apply consistency in the rule of law with how this particular entity has approached these questions in the past. And if quoting an agency's conclusion were enough, then, quote, the officer was sued, end quote, or investigated or audited or anything else like that, that would become a recall ground. Recall by accusation. We can't have that here in Michigan. And that has been the standard since 1926. So picture a signer on the sidewalk. What do you see? This petition language, if it came in front of them, would say what the state did to the clerk. It never tells her what the clerk did. She would be signing it blind. And MCL 168.951A exists precisely to prevent something like this. The reason must let the electors identify the officer's conduct. And in conclusion, page 3 of our motion, on page 3 of our submission, we have a proposed motion given to the lack of particularity, specificity, and the other defects. And I welcome the questions of the board. Thank you.
Thank you, sir. Questions? Okay. Question?
No.
Cordes, questions? No. Thank you for your time.
Thank you.
Quiet group this morning. You've heard the arguments on both sides. We've read the petition language. Vice Chair, do you have comments?
I do. What this recall petition states, there are essentially two phrases. One is what the Bureau of Elections did, suspended her access to the QVF. The other phrase is stating that her actions fell outside the scope of her statutory authority. So that does describe, that second phrase, what it is that the recalled officer did, acted outside the scope of her statutory authority. If one put the phrases in a different order and said Victoria Bishop acted outside, or that she acted outside the scope of her statutory authority, and thereby the Michigan Bureau of Elections suspended her access to the QVF, I think it would say the same thing. I don't think it matters that the second phrase is here. It's the second phrase rather than the first.
But isn't it relevant though that it says that because what you said is different than what I'm reading, which is that the Michigan Bureau of Elections suspended Victoria access to the state QVF, stating like they're saying that the Michigan Bureau of Elections stated that rather than as Mr. Kiefsky said, that an accusation being made by the
Slight variation.
yeah.
That her actions fell outside according to Bureau of Elections.
Yes.
I might have phrased it differently myself.
Yeah.
That's not the issue. I think that when we last addressed the recall petition, we all recognized that we would have said it differently, but the question was whether it gave the officer and people whose signature was sought, whether it was sufficiently clear for those purposes. Um,
Yeah, I wanted to add that it has a very specific date, which has been an issue we've had in the past when it's open and not specific. I do agree with Vice Chair Gurwitz. I would not have written it this way. I don't think it's the most effective way. However, I really appreciated Ms. Arita's argument regarding not everyone's an attorney and that we have to trust the electors on this. I think that's very important as I sit here today. I do have to congratulate you, Mr. Is it Kieski, sorry, Mr. Kieski. Your letter was very persuasive. But at the end of the day, I feel it is sufficient enough. When I read it before reading anybody's opinions and legalese, I found that it was sufficient. So that's how I feel about it today. Thank you.
Thank you. Director Brader, I understand that the Bureau does not make recommendations here, but I would like to ask you a question. The question is simply, is this an ongoing or a closed issue?
Ongoing.
It's ongoing. So this is not something that's even been finalized yet. I mean, I
Well,
understand that you've suspended the access to the QVF, but the reasons for that and the circumstances and all of that is discussion that's ongoing, correct?
Yeah, the reasons for when her access was suspended, there were a number of conditions that she was to meet in order to have her access restored. Those have not yet been met. So we're still in correspondence with the clerk, and she still does not have access to QVF.
Which means that the suspension is effective at the
Ongoing.
current time.
At the current time,
Right.
yeah. Yep.
My question would be, obviously, you have a lot of trust in the Michigan Bureau of Elections. Would you read this differently if it was a different entity replaced with the Michigan Bureau of Elections, right? If there was someone else who had done something to Victoria Bishop and they said that her actions fell outside of the scope of her statutory authority. Because they're the ones, again, as Mr. Kiyosaki said, making the accusation. There's someone else making an accusation here, right?
Act is that, oh, I'm sorry. The operative fact is that her access to the QVF is suspended. And she is the clerk of the county, and not having access to the QVF is a significant thing. So, and Director Brader just said that that suspension continues to be effective. So I don't know who else you suggest might have done something with. regard
I'm
to
just
Ms.
saying,
Brader.
like, my only point here is, and I have the MCL pulled up, which says based on the officer's conduct, right? And this basically talks about, it is another entity that has done something to the clerk and made an accusation towards the clerk. I understand it's factual. I'm not arguing that that's not factual.
We've
I
had
don't-
this before with county boards and we've
Yeah.
had it with other groups. The trick is it comes back to what Vice Chair Gurwitz stated originally, and that is the wording on this petition is convoluted. And it's completely out of order. That's why you're reading it that way. That's why I'm reading it that way.
Right. I didn't say it was convoluted. I think it's pretty
I use that-
straightforward.
Yeah.
I do think it's straightforward, that there are essentially two facts stated, that her access to the QVF is suspended, and that her actions fell outside the scope of her statutory authority. Those are two
Those two
clear
facts, right? Well,
statements.
yes, that she's been accused of her actions falling outside the scope of her statutory authority and that the Bureau of Elections has suspended. Those are both
Right.
facts.
Right. As I said, I might have put it differently, but I think it's sufficiently clear. I think that Ms. Bishop would undoubtedly understand what the assertion is here. And I think that people in Antrim County whose signature on a recall petition is sought would also understand that their clerk's access to the QVF is suspended because of the way in which she acted outside the scope of her authority.
I think that's a really good point because we battled with this with the recall of the prosecutor up in Traverse City with the fact of we wanted to make sure the person who's being recalled understood what it was about. And that was a big issue for us on the other petition was it wasn't clear. There's no doubt in my mind that this clerk understands what's being alleged. And the people in the county, again, would understand it probably more than I do. Well, maybe not, but I mean, it's back to trusting the electors. And back to your point, Paul, if it's, I understand what you're saying. If it's someone less credible than, you know, the Bureau.
Yeah.
Lodging a complaint or lodging some slanderous accusation, I trust the people as well. I mean, I'd have to see the petition, but I think it's important for us to not be too heavy-handed with these petitions. And I think having the date, having the actual conduct and what happened suffices.
All right. Is there any other discussion on this? Anything that we need to add to the conversation? I would entertain a motion.
Sure. I move that the Board of State Canvassers determine that the reasons for recall printed on the petition submitted by Ashley Arita against Antrim County Clerk Victoria Bishop on July 6, 2026 are factual and sufficiently clear because there is a date listed. It provides the conduct against, because there's a date listed, it provides the conduct of the clerk being, oh my goodness. Can I strike it?
Would you like to try that again?
Sorry. I move that the Board of State Canvassers determine that the reasons for recall printed on the petition submitted by Ashley Arita against Antrim County Clerk Victoria Bishop on July 6, 2026 are factually and sufficiently clear because there is a date, it discusses the conduct, and it provides the reason why this petition seeks suspension, seeks a recall.
Second.
Been moved and seconded. All in favor?
Aye.
All opposed?
No.
Yeah, I've got to take a no on this one too. Thank you. Moving on.
So,
Oops, go
Well,
ahead.
we should make clear
Yes,
that the fact that we split on this means that the board has not approved the reason for recall.
I can do that. I can do that. Yes, okay. So what's happened is that because the board split, the reasons for recall were not approved. The petition is not blessed. It does not move forward. Yeah,
Don't mind explaining my no vote as well, so that they know if you want to come back, which is just, I mean, it does say, I agree that these petitions can't be based on just what other people are saying about it. Again, the Bureau obviously has is a respected institution, so, you know, I understand exactly what the argument here is, but it very clearly says must be based upon the officer's conduct. And this is just the Bureau taking an action, making an accusation. If there is a factual accusation to be made by the petitioner, I think that solves the problem.
yeah, okay. So if you're going to go that way, I'll give you my reasons as well. I'll make it short. This is an ongoing consideration. This is the Bureau of Elections is still involved with the clerk in Antrim County. There's no determination that's been made here. You know what? At the end of this meeting, Director Brader could get a call from the Antrim County clerk who might say to him, wow, I've changed the way I'm going to do business in the future. He might say, this is wonderful. Tomorrow she could have access to the QVF and everybody be happy. This, will that happen? No, it won't. But the point being is that in the realm of possibility, it can. And so this is an open matter. In a lot of the petitions that we've looked at for recall, it's been for action that's happened in the past. That's also action that has been concluded in the past, as in the case of the prosecutor in Traverse City. That wasn't an ongoing case. That was something she did. The case was closed. That is not what's happening here. And so this is something that could still be recovered. It could still be worked through. And by the way, probably will be. So, well, you know.
I shouldn't say that, but,
Go
you
ahead.
know, we've already made a decision, but maybe we
Yeah.
can clarify a little bit more. And just to say that the suspension happened. It may be lifted, but it happened. And it is currently in effect. So, the fact that it might be remedied later on does not change the fact that it existed.
Could I just add a procedural note?
Oh, please, go ahead.
It's helpful that you clarify that. So the reason that, and AG's office, please correct me if I'm wrong here, but the reason that in the motions that we draft for you, that we put the because on there is because I believe there's a court case that related to a entity seeking to recall. If the board rejects those reasons, that there needs to be some sort of notice or explanation given to that party so that they can correct that in the future. It's obviously a little different in this situation because the board deadlocked. There wasn't a motion to find that the reasons are not sufficiently clear and factual, but the outcome is that it's a rejection. So I think it is helpful that you provided that clarity.
Do we need further explanation?
I think the board has explained its individual reasons, so I don't think that there's anything more that needs to be said.
In terms of how it could be recast or restated, is that what you're?
Yeah, it's not the board's obligation to explain what would be a sufficient petition, but I think you've explained your reasons for why this petition was rejected.
You mind if I go that way? You can, would you like to?
Yeah.
Okay. I think that if this petition had been brought to us and this petition were structured in a way that focused more on the county clerk's specific actions. The fact that QVF has been taken away from her. If you had come in here and you said that the Antrim County clerk has scounded on her responsibility or stepped outside of her scope by doing this and this, and these are her actions, we would probably look at it differently. I figured you would probably be back, yeah, kind of a revolving door, yeah. Thanks for coming. Thank you. Good to go? All right. Item number 3. The assignment of the number designation for the Constitutional Convention ballot question. I have to believe this is not going to be a major discussion. Director Brader, do you want to pick that one up?
Sure. The Constitution requires every 16 years that the question of holding a constitutional convention be put before the voters. That is up this year for 2026. We're going to talk in a moment about the language that will appear on that, which there'll probably be more discussion of. But the law is quite clear, Section 474A, that when this constitutional convention question comes up, that it gets the first number. So this will be numbered as 2026-1, regardless of whatever else is on the ballot.
Okay. Do we need additional conversation or can we do a motion on this right now? Perfect.
I move that the Board of State Canvassers designate the question of a general revision of the Constitution as proposal 2026-1 on the November 3rd, 2026 general election ballot.
Second.
Been moved and seconded. All in favor?
Aye.
Aye.
Moving along, item number 4 is the consideration of the 100-word summary of purpose for the Constitutional Convention ballot question. The language as drafted by the Director of Elections is, and Director Prater, would you read that for us?
Yes, Proposal 2026-1, and the header is a proposal to convene a constitutional convention for the purpose of drafting a general revision of the state constitution. And the language, the question presented to the voters is, shall a convention of delegates to be elected at a partisan special election be convened in 2027 to draft a general revision of the state constitution for presentation to the state's voters for their approval or rejection? Yes or no?
Thank you, Director. Representing the Constitutional Convention questions, Christina, would you, there you go. You got the first one out of the way. Would you state your name and spell it for the clerk, please?
I will. Good morning.
Good.
My name is Christina Grassi. I am here representing Protect Michigan's Constitution from Special Interests, which is a ballot question committee that was formed in opposition to the Constitutional Convention question. So thank you for having me this morning. The question that the director just read that is presented to you in Proposal 2026-1, we actually advocated for that language. And 2 objections have been filed with the board, one by the Michigan Chamber of Commerce and the other by Voters Not Politicians. Those organizations shared their comments with me before this meeting so we could see them. And I'm actually here, I'll put the spoiler up front. I'm actually going to agree with the objections. So I don't know how often that happens, but I'm here to bring harmony to the Board of State Canvassers meeting on this particular proposal.
Our support.
I'll explain why. So we advocated, well, let me back up. As the director indicated, this proposal is unusual in that it must be submitted to voters every 16 years. So the first time voters saw it was 1978. They saw it again in 1994. And the last time they voted on it was 2010. So it is a concept that voters have seen. Some voters will vote this year and they've seen it 3 times, some 2, some 1, some of this will be the first time. The objections filed by the chamber and Voters Not Politicians are essentially, look, don't change the language because voters have seen it before. Voters Not Politicians says that the language that we added, which is actually the partisan special election language, is confusing, but even beyond that, the fact that you are changing the language could confuse some voters. I will say the language has been remarkably consistent since 1978. There were slight modifications made to the 1978 language in 1994 to the title and the summary, and then the 2010 language was the same as it was in 1994. So when we received the objections from these organizations, I did some additional research. I call it market research, but really I was looking at media attention and voter education outreach on this proposal. And I was surprised to find there's a lot of attention on this proposal, and there has been voter education efforts from as early as I found as the beginning of the year. Some is media attention, some are organizations like Citizens Research Council, which is doing like a series of 15-page different papers about what the Constitutional Convention is. And in these media accounts and voter education materials, oftentimes they cite 2026-1 by title, and they use the 2010 ballot language already. And Voters Not Politicians gives a nod to this in their opposition. They cite Ballotpedia, and they say, well, when you look at Ballotpedia, it already has 2026-1, and it's got the language from 2010. So I will tell you, I talked about it with my client, and our number one concern is that voters are not confused about this. The Constitutional Convention is already a confusing topic, and we don't want people to question why this 2026 language is different than it has been previously and inject additional confusion. So though we advocated for what you see before you, I'm going to do something I haven't done in 20 years of practice, which is ask you to not give me the thing that I asked for. Instead, I'm going to ask you to adopt the 2010 language that has been previously used. I have it with me if you would like to see it, but the long story short, I agree with the concerns of the objectors, and we just can't have this be a confusing question for people who have seen it before.
Would you read that language for us?
Yes, sir, I can. So the 2010 language that we'd ask you to adopt The title would be the same as you have before you, but the question would be, shall a convention of elected delegates be convened in 2027 to draft a general revision of the state constitution for presentation to the state's voters for their approval or rejection?
Thank you.
You're welcome.
Any questions?
Thank you very much for your presentation.
Like I said, just a little bit of harmony at the beginning of the
Really
meeting.
do make it easier for us.
Thank you.
4 days? We're going to get to Director Brader right away, yes.
I guess I shouldn't read the submissions anymore. Would have been easier just to leave it the way it was. So, so at the outset, I'll say, I think either the language used in 2010 or the language that I proposed would meet the statutory standard. We'll talk about this more with the other language if we get to that, but there isn't obviously one set of words that is the only magic words that meet the statutory standard. I will say, I mean, if because either one meets the standard, I'm happy to submit either one to the board and happy to have the board approve either. And if there seems to be general consensus that the language in 2010 is preferable, then that's fine with me. I will say, I think the idea that people will be confused because the language is different than something they saw on the ballot 16 years ago is a bit of a stretch. I don't remember what it looked like 16 years ago, but maybe some people just are quite photographic in their experience with old ballots. Having said that, I mean, there is obviously some media attention as indicated, and so that could be a cause for confusion. The reason that I did agree with the submission was that in looking at the actual language of the state constitution, which is Article 12, Section 3, it does describe the manner in which those delegates will be selected, right? So the 2010 language says like, shall delegates be selected? And when I looked at the Constitution does, as the submission indicated, provide for a partisan election that has to be a special election because it has to be held within 6 months of the past November election. And that partisan election elects delegates from each district, essentially. So as I read the comment and looked at the Constitution, I thought that without that language in there, there could be a question about how those delegates are selected. And so in apprising voters on the substance of the question being presented, I thought it was helpful to include that information. But I don't think it's absolutely essential. I think that without that language, it would also meet the statutory standard. So I'm not going to fight for what I submitted if people prefer the other language, but I think either one would be fine.
How does the board feel?
I have a loud voice anyway. I think the argument regarding the media is very persuasive for me because I did actually see the old language printed, and that is extremely confusing. And I agree with you, it was 16 years ago. I think for some people it'll be their first times. I don't remember, and I'm sure I voted on it. I don't remember the exact language, but the fact that the media is using the old language, I think personally being consistent, I don't think this is something that's needs to be changed.
I'll disagree with you on that. I don't think the media should be the one that drafts the language for the proposal. But I do think that there is a good argument to be made that we should stick with the language that we have used in prior elections or prior proposals. So I would agree that the language which was read to us by Ms. Grassi, I would agree that that should be the language that we put on the ballot proposal.
It makes sense. I think in a time when everything is, when we all have a lot of change and there's a lot of turbulence right now in our society and elections, in what we do as a culture. This wording that goes back all these 16-year cycles is a little like an old Bob Dylan song, right? You hear it and it keeps playing in your head and there's a comfort level to it. And so at the risk of being corny that way, the traditional side of this, the repetitive, is kind of like a middle C, isn't it? And so, Christina, I really appreciate you taking that position. And, I'd support the same thing. But, Cordes, do you want to add to that?
I don't know about all the Bob Dylan stuff, but I'm good with the previous language.
You want me to send you something? So that being the case, though, I have a technical question. Director Brader, rather than have us vote on the wording here, would it make more sense to have you folks redraft it and then bring it up on the agenda later and vote on it, or why do you want to do that?
We've redrafted it, so we could read it in now unless you want to
Good.
print it out. We can just read it in and I think the board can vote on that.
If we can do that, then let's please read it in and we'll take a vote now.
So the revised proposed language, just the proposal and the header are the same, but the rest of the language is different. So the revised proposed language is proposal 2026-1, a proposal to convene a constitutional convention for the purpose of drafting a general revision of the state constitution. Shall a convention of elected delegates be convened in 2027 to draft a general revision of the state constitution for presentation to the state's voters for their approval or rejection? Yes or no?
I move that the Board of State Canvassers approve the revised statement of purpose prepared and submitted on July 24th, 2026 by the Director of Elections for Proposal 2026-1 on the November 3rd, 2026 general election ballot.
Second.
And moved and seconded, all in favor?
Aye.
Yes, eventually we were going to get here, weren't we? Moving on to item number 5, which is what's filled the room. We have a consideration of the sufficiency of the initiation of legislation submitted by Michiganders for Money Out of Politics. We have a number of folks here representing both challengers and petitioners. I'm open to who wants to go first.
Right. Good morning. My name is Gary Gordon, and with Olivia Flower and Eric Doster, represent the ballot question committee known as Protect Michigan Speech, formed in opposition to the ballot proposal. We're here to end the harmony that began with
That might be the case, but before you continue, do you need to give your spelling and all to the clerk?
We filled out the form, Gary Gordon, Gordon.
Okay. All right.
Mr. Doster, do you want a chair? You look menacing.
Get a chair.
But I'm good. I'm good. The way we're gonna tag team this.
Okay.
Well, Mr. Gordon will take a chair now, and then he'll sit up and I'll take a chair.
I'll move. We, because of the complexity of some of the issues we're presenting, we've divvied this up into 3 parts. I'm doing the easy stuff, and Ms. Flower and Mr. Doster will deal with some of the complicated issues that we raise. If I may,
You can. There was one item I'd like, can I put one piece out here as long as we're starting this? And I apologize. I meant to do this when we first started this process on number 5. I think before you speak, I meant to have Director Brader give the staff report, and I omitted that. And Director Brader, before you give the staff report, just kind of a way that we're going to walk through this. The staff report and some of the responses and some of the challenges have structured this in a very outliney sort of way. Table by table, cause by cause. It's complicated issues. And so I would like Director Brader to give the staff report before you start. But then in addition to that, as we walk through that, I would like to use that format for how we hear and respond to that this morning. Is that fair?
yes, that's
So
fine.
whoever Director Brader will bring it in and you can go.
Okay, thank you, Chair Housecamp. So this is a proposed initiated law submitted by Michiganders for Money Out of Politics. The number of valid signatures required is 356,958. And the total filing was 561,282 signatures. Based on the board's approved methodology, we use random sampling for this petition with a random sample of 1,000 signatures. And so they would need to have 636 or more valid signatures out of that 1,000. to meet the requirements of a projected sufficient number of valid signatures. So when we first reviewed the sample, we determined that 799 of the signatures within the sample were valid. We found we found 107 within that 1,000 that were not registered to vote, and we found 67 that were invalid signatures and a few other categories that knocked it down to 799. We then received a challenge from Protect My Free Speech and James Holcomb. I'll just collectively just say Protect My Free Speech, that raised challenges to 432 of the sampled signatures for a variety of reasons: potential forgeries, signature errors, duplicate signatures, signatures not registered to vote, circulator errors, jurisdictional issues, address issues, and then allegations that the signers were deceased. So because the cushion that we had at 799 was only 163 over the 636 required, and they had challenged 432, we did process the challenge. After reviewing the challenge, we did disqualify an additional 132, if my math is right there, signatures, which took it down to 657. The largest category of additional signatures that we found to be invalid were duplicates. So when we review the sample, under the board's policy, I should first say that if an individual signs a petition multiple times, both signatures are thrown out. When we review the sample, we look for duplicates within the sample, but there are, of course, is the possibility, likelihood, that there will be signatures that are duplicated twice in the entire universe of all the signatures in the petition that are not duplicated within the sample. That's not something that we have the capacity to look for, but when challengers raise it, we review what they've submitted, and if we find that a duplicate signature exists, that is, there is a signature in the sample, and there's also a signature outside the sample from the same person, we will determine that signature to be invalid on the basis of it being a duplicate. One thing I should note about that is, in order for it to be determined to be a duplicate, both signatures need to be otherwise valid. So if one of those signatures is invalid for some other reason, it's not considered a duplicate because there's actually only one valid signature within the petition. So we did agree that there were 102 of those, and then there were a few others that we agreed with, some additional invalid signatures, signer not registered to vote, and then also some circulator information missing, which took it down to 657. There are, the staff board does go through all the categories and how we responded to the challenge. So I'm not going to read that all verbatim. It's already been read, obviously, but we go through basically indications that the challengers thought were illegible writing, the duplicates, which I already talked about, invalid signatures, so signatures that don't match the signature on file, non-registered voters, and address and jurisdictional errors, so not writing the proper jurisdiction or not being in the jurisdiction, date errors, errors as to form, which I'll talk about in a moment, circulator errors, and signatures from deceased individuals, circulators that were alleged to be having signatures from deceased individuals, potentially forged signatures, potentially forged signatures of multiple types. So as we went through all of those and we accepted some of those challenges, we disagreed with some of those challenges overlapped with the determinations we had already met, we were left with 657 valid signatures. Two more issues I want to just touch on, and then we can, we're probably best off getting into the parties so that we can discuss this in more detail. There were challenges that were raised to circulator signatures who did not write the allegation was they did not write a valid jurisdiction, municipal jurisdiction on the circulator block. This was the issue that came up in Wickman, the Wickman case, which we discussed with respect to candidate petitions. It's more applicable here because the Wickman case was about initiative petitions. We did agree with some of the circulator challenges, but where we disagreed with the challengers was that we do not believe, the Bureau of Elections does not believe that Wickman applies or has a rule for out-of-state circulators. The Wickman Court is talking about jurisdictions within Michigan and distinguishing between cities and townships and unincorporated places when it comes to Michigan circulators. It doesn't discuss what happens out of state. And of course, other states have totally different subdivisions municipally. Some of them have towns. Some of them organize their elections differently with respect to counties. At least one state uses parishes. So it's not clear how, if at all, the Wickman case would apply to situations where the circulator may have written a place that the allegation is unincorporated according to the out-of-state law. It's just not something that we think Wickman covers and that we have the capacity to make a recommendation on. So we did not reject any signatures on the basis that an out-of-state circulator wrote an allegedly unincorporated place. But that was something the challengers raised. And then the final issue is there were some form issues and missing required elements that related to the physical pieces of paper in the sample. So when we adopted this new policy of sampling, we changed the way that we process signatures. In the past, the Bureau of Elections would look at every physical sheet first. So we'd go through 10,000 or more physical sheets, review them all. Then we would pull a physical sample. We would hand stamp every sheet. And then we would make those available for challengers or anybody else who wanted to actually come in and scan them. That's how we used to do things. It took a very long time. It pushed the process back up against the deadline because of the amount of time it took to manually pull and review all of the paper sheets and then make them available for inspection. So under the board's policy, updated policy, the first thing we do is scan all the sheets. We scan the entire sheet. We make the universe of signatures available in all the sheets. And then we also draw a digital sample. So we digitally pull sheets from the universe of sheets to comprise a sample. And then we make that digital sample available. That has the benefit of being much faster. We're able to get sheets out and start reviewing them much more quickly, which allows us to move the process out ahead of the board meeting, also allows us to have the staff report available 7 days before the board meeting, allows parties more time. So that's the good side. The downside of the way we do it now is that we still need to go in and actually pull out those physical pieces of paper from the sample so that the physical paper sheets are available. So in this case, we had pulled the digital sample of sheets and then made them available. After we did that, the challengers indicated that they wanted to inspect the physical pieces of paper. So we were in the process of pulling the paper sheets, but because of the amount of time it takes to go through and look for each piece of paper within each box, we were not able to review most of those sheets or pull most of those sheets until after the challenge deadline. So what we did was we made about, I think it was about 150, 160 of those pieces of paper available before the challenge deadline. The challengers made challenges based on a few of those sheets. And then we continued to make them available on a rolling basis over the next few days. And we thought, as of July 15th, that we had pulled out all the pieces of paper and made them available for the challengers as of that date. The reason that someone might want to look at the piece of paper as opposed to the sample, the digital sheet, is that you might want to look at the back side of the sheet to see if there's, for example, an error in the way that the language is printed on the back of the sheet, or there might have been a tear or bleed through of ink or whiteout that might obscure some required element on the sheet that would throw it out that you may not see just by looking at the front of the sheet. So while we look at the front of the sheet and we disqualify signatures based on the signatures and anything else that's available on the front of the sheet, we also do then need to look at the back of the sheet just to make sure there's nothing, pull out the piece of paper and look at the back of the sheet just to make sure that there's nothing missing. So what we indicated to the challengers was that we understood that they couldn't include all of their findings from looking at the piece of paper by the challenge deadline, but that we would continue to make them available and that they could include any objections they had based on the pieces of paper in response to our staff report, which they did. But then as we were preparing for the board meeting on Wednesday and going through the physical sheets, we discovered that while we thought we had pulled out all the pieces of paper, there was actually about 200 physical pieces of paper from the sample that we had not retrieved. So we notified the challenger, notified the the sponsor as well as the chair and the vice chair. We then pulled them out as quickly as we could, stayed late Wednesday evening to get them all out, made them available to the challenger yesterday, as well as the sponsor. So we have now actually reviewed all those pieces of paper, and the challengers have as well. So, generally speaking, there's a 48-hour cutoff for submitting materials to the board. Obviously, I encourage the board to hear what each side has to say about this information that they just learned about yesterday. Ultimately, although we obviously want to improve this process of making these physical pieces of paper available, and we obviously made an error in not retrieving them all when we thought we had, it doesn't affect our determination because there's only a handful of sheets that are really in question as relates to errors that are only apparent from looking at the back of the sheet. So it doesn't affect our recommendation to you in terms of the fact that we only yesterday or only Wednesday night actually pulled out the rest of those pieces of paper. But it is something that we're going to need to talk to the board about and get feedback from sponsors and challengers going forward about a better way of handling the pieces of paper, which I think is something that we didn't sufficiently account for in this overall improved process that we have. The other thing that we discovered, actually, I think it was yesterday, was that there was one sheet that had been scanned twice. So the digital sample and the digital universe of sheets we have is slightly inaccurate because there's one piece of paper, quote unquote, piece of paper in the digital universe of sheets and the digital sample of sheets twice. So that would, not affect the determination because ultimately they have a cushion of, I think, 21 signatures. But that was another issue we discovered that we need to figure out a better way of handling going forward. I think that is all I have to tell you now. I will yield back because I know we have a lot to talk about. But ultimately, based on a review of the sample, a review of the challenge, and then also some information that the challengers and others have submitted after our staff report, it remains our recommendation that the petition be determined sufficient because we do estimate that it has a sufficient number of valid signatures.
Thank you, Director.
Chair Housekamp, with your indulgence, I'd like to kind of talk about an overview before we get into some of the detail on the challenges that are outstanding. The presentation by staff reinforces kind of a theme we have here, that this has been a rushed process and there've been a lot of errors made, mistakes interpreting policies that the board supposedly has, mistakes in interpreting the statute, including the Whitman case we just discussed, and then we'll get into more detail. As I noted, I represent with Mr. Doster and Ms. Flower, Michigan, Protect Michigan Free Speech, and James Holcomb, who was the presented the sworn challenge. We're here to demonstrate why there aren't enough valid signatures to certify the proposal to the ballot. The sample of 1,000 signatures that they took is out of a claimed universe of over 561,000 signatures that were filed. They were filed at the absolute last point in time under the statute they could be filed. In order to have enough valid signatures, the petitioners, and this is the staff's computations, had to demonstrate that at least 63.6% of the signatures were valid. The staff found before these changes, and I'm not sure what the percentages would be now, but they found in their initial report, 65.7% were valid. But they also noted that there was a margin of error of plus or minus 2.5% in the sample. If you do the math, and if the 2.5% error rate falls to the negative, then that drops the validity rate to 63.2%, which is below the margin of error. That's not adequate for this board to rule with certainty that there are enough valid signatures presented. Additionally, the staff, we think, erroneously approved 45, now I think 44, although the numbers keep moving, signatures that if were rejected would bring the total valid signatures well below the 636 provided for certification. I think the number is 612. In the limited time that we were able to review the signature sample and the universe, it became apparent that the petitions are sloppy. They contain numerous errors, including non-existent addresses, dead people signing, individuals not registered to vote, and most egregiously, persons signing multiple times. In one instance, at least 8 times. 15%, almost 15% of the sample contains signatures of people who signed the petitions more than once. Now, we admire the staff. We respect the professionalism and the dedication of the staff, doing sometimes almost impossible jobs under extremely constrained time. But here, we think the staff review of these petitions was truncated by the petitioners gaming the system. They gamed the system by filing way more than the number of signatures they required, thereby increasing the burden on the staff, and they waited till the last minute. They were surely aware when they filed that the staff would be dealing with at least one other ballot proposal and the hotly contested statewide race for governor, where there were multiple challenges to candidate petitions that this board would have to consider and the staff would have to process. The petitioners apparently banked on the possibility that a hurried staff review wouldn't disclose the large number of invalid signatures. That didn't work. We've demonstrated that a number of valid signatures falls below the required number to certify. Maybe due to the last minute filing, staff failed to find circulator, signers errors, duplicate signatures, and as I noted, we think misinterpreted the law and based some of their decisions on alleged board policies, a record of which we can't find anywhere. In addition to staff, we've also been the victims of this gaming of the system. A timeline of our petition review process is listed on page 22 of our July 21 filing. For example, the staff took nearly 1 month to respond to our Freedom of Information Act request for the full petition universe. But after making the universe available for only 1 day, they immediately, the next day, issued a partial sample and then followed up with the remainder of the sample 1 day later, which deprived us of the possibility of examining the universe in any detail prior to the sample. We requested the right to inspect the physical petition sheets of the sample on June 29. On July 2, the staff made 140 sheets out of the 1,000 available. Finally, on July 14, which is 4 days after our challenges were due, the staff claims it made the remaining 860 sheets available. But in another error, as was detailed by the director, again, probably caused by the crush of time constraints on the gaming of the system, filing this massive amount of signatures at the last minute, the staff made a mistake. They realized they hadn't provided all the sheets for review, and they found an additional, we think, 284 sheets. We were notified of that on Wednesday. We were told that they'd make the petitions available yesterday morning for 2 hours, and then maybe later in the afternoon for us to review. We reviewed those sheets and sent a letter to the board noting that we found additional signatures that should be rejected as valid. Ms. Fowler is going to address that in detail. These errors piled up, we think, cast doubt on the staff, on the validity of the staff recommendation. It's a very close issue. They will admit that, especially when you consider the additional invalid signatures that we want to talk about a little later. There's no certainty to the staff recommendation. It should be recommended. It's the duty, remember, it's the duty of the board. And we have section 476 here, not the staff. It's your duty, not the staff, to determine whether enough valid signatures were filed. Some of the staff rejections of our challenges were not based on, as I said, any reasonable construction of the case law, especially the one just discussed. In addition to the missteps I noticed, there's others. For example, the staff initially claimed that there were 799 valid signatures in the staff report. But after reviewing the challenges that we admitted, the staff admitted that it missed an additional 142 signatures that weren't valid, that we brought to their attention. That brought the estimate down to 657 signatures. In their initial review, they only found 2 duplicate signatures. We found 148. Some, or one who signed as many as 8 times. When we pointed that out to the staff, they agreed with 102 of the duplicate signatures, rejected some because they were invalid for other reasons, but for unknown reasons, rejected 12 that were still in the universe and had not been rejected for other reasons. We'll talk about those. The staff itself admits, again, that the basis of its recommendation to approve is within the margin of error. In fact, it's possible, as I noted, that the sampling is outside the error, thereby casting the recommendation beyond any reasonable range of reliability. And again, this is without considering the invalid signatures detailed in our July 21 filing that were improperly accepted by staff. So again, the 2.5% margin of error is in the minus. If it's in the minus range, it's below any reasonable doubt, and there's no certainty that you should approve this. A guess isn't good enough to certify something to the ballot to the 8 million voters of the state of Michigan. As opposed to here, the last 2 ballot proposals that were certified by this board, instead of having a range in the low 60%, had a validity rate of 81.1% and 78.3% validity. The staff said it had 100% confidence that there were enough valid signatures presented for a certification of those last 2 proposals. They haven't stated that here. They don't have 100% confidence level. In fact, their confidence level is based on numbers that are within the range of the margin of error. We haven't found any other examples of the board certifying petitions that fall within this low range. Maybe they're out there, but we couldn't find them. Again, it's your decision, not that of the board. We hesitate to criticize the staff because we know the constraints they're under. We appreciate their professionalism and their competence, but here we think they blew it. There's not enough signatures. The petitions are sloppy, contain numerous duplicates, unregistered voters, and dead signers. We'll detail these in the rest of our presentation. But even without the removal of the improperly accepted invalid signatures, the percentage, again, is within the margin of error. If it disfavors petitioners, the finding is that there are not enough valid signatures to be certified. We ask the board refuse to certify these petitions, or at a minimum, invoke its authority under section 476 to begin further investigations of these petitions. Now, we've brought exhibits to make our presentation a little bit easier for the board, and I would defer to Ms. Flower at this point.
Thank you.
Sit here.
All right, so I had a few remarks prepared, but I think Mr. Gordon covered most of it, so let's jump into it. The one thing that I would note before we dive in sort of item by item, as the board has indicated it would like to process our challenge, is that each line matters at this point. I don't necessarily agree with Director Brader's statement that the errors that they're identifying at this point leave the results unchanged. When you look at all of these things that we've identified altogether, they're certainly dispositive of whether or not the board certifies today. So I'm going to take you through each category of the remaining challenges, and the authority to determine those challenges remains with the board. The board seeks advice and recommendations from the Bureau, but ultimately the decision and statutory authority to regarding whether this measure has met its constitutional required threshold rests with you. We're going to cover a lot of ground, so please don't hesitate to engage, ask questions as they may come to you. And so how we're gonna, our plan to start is to go sort of category by category. But we do have each sheet available to you if you want to say, you know what, I want to look at all 10 of the ones that you're talking about. Let's go through them sheet by sheet. We're ready to do that. So where we had like to start would be duplicates. So duplicates, as we noted, the staff report found 2, we found 148. The staff report accepted 102 of those challenges. 30 and change were overlapped with other invalid codes that the Bureau had already discovered in their initial review, and they rejected 12. So what they said in the staff report was that that was generally because the other signatures were found to be invalid. On our review of, we've isolated it down to 10. We see no reason why the universe signature would be invalid. So we do have an example here of each. Our first is, I believe, Sandra Cotright. The one with the, obviously, like with the sampling process, the one with the blue dot is the one in the sample, and the other one is the universe signature. We can also pull this up on the screen if that would be helpful. It is also in our July 21st letter. We have each row of the duplicates pulled out for easy reference.
Yeah, put it right up there.
And just as a reminder, the manual indicates that a signature is invalid if a signer signs the petition more than once. And the Michigan election law provides that a person who knowingly signs the petition more than once is violating the provisions of the Michigan election law. And there's precedent going all the way back to 1940 that in Michigan, you don't count one, we knock them both out. Yes.
So
Yes.
we, a few minutes ago, heard Director Brader talk about if one of the, so let's say there's duplicates. One is invalid because for whatever reason.
Didn't date it or something, yeah.
Yeah, then they do count the one, they strike that one, but do count the one. Do you agree with that or do you not agree with that?
We agree with that practice. We don't agree that the 10 that we've identified fall in that category.
Okay.
Yeah.
Thank you.
And we weren't provided like a line by line, the universe is valid because of X, Y, or Z.
Right.
So can you explain what we're supposed to be discerning from these exhibits?
Certainly.
And-
Okay, can I approach, may I approach?
Oh, absolutely.
Okay.
Yeah. This is not a court. that you could approach.
Sample signature. Essay Conwright, address Detroit, zip code, and date. This is the universe. The signer in this case appeared to write S.A. Conwright both times and then printed out their full name in the certificate. That this makes no difference. This has the same signature, same name, exact same address, Detroit, zip code, and date. It's indiscernible why that would be valid. There doesn't seem to be anything on circulator law.
So you're saying that these are two otherwise valid signatures, but they're dupes?
Yes.
And you're saying that the staff determination was that one of these was that the duplicate in the universe was invalid.
So let's next example.
I mean, I just want to understand what your difference of opinion is with regard to the staff report.
You have it exactly. The staff has indicated that the signature in the universe is invalid for some reason. And we're looking at it and we're saying there's no reason. That is a valid signature. So you've
Okay.
encapsulated the issue exactly.
I know,
If I might, just this.
Yes.
Yeah, that's the problem.
yeah.
So let's move on to the next one. So for this example, we have, oops, didn't see that. We have Sean Frew. He has his date, or I think this is on page in their July 21.
Yeah.
Filing as well. Binder 4/21/26, 4/21/2026. This is the university. We have the other one. So this would be the ballot one. For some reason, go back. The Bureau believes that this one is invalid. Both dated 4/21.
Ms. Flowers, did you say the July 21st letter?
I think your comparisons are from page 5 to page 7.
Yeah.
Right.
Thank you.
So what you've got here
Mhm.
are just, you've blown up these comparisons that you wanted to look
Yeah.
at. It's
And I made
probably
the full sheet
easier
available.
for us to look
Yeah.
at your letter. But I understand what you're doing here. It's just that it's a little hard to read. Yeah. Oh, okay.
Yes,
But
for ease of reference. Yes.
Right.
It is also
I'll just put
exhibit
this
A
right here and we can share it.
for reference. So yes, we are on the second page. So this appears to be a fully valid line.
So are we talking about Sean
Sean Prude.
Boot? Okay.
Are we finished? I'm sorry. Are we finished with Sandra?
Staff indicated that the date they rejected for the circulator date. We had no, like, because we weren't provided with the line by line response of why
Okay.
each was considered invalid, we had no information regarding why that would not be considered a valid duplicate.
So do you know?
For Sandra, certainly, we would concede
Okay,
that
so
Sandra.
Sandra's.
Yeah, Sandra's
Okay.
out.
Sorry.
We're not counting Sandra's now because of the.
Wait, no.
Sorry, just to clarify, it's like reverse when we're talking about duplicates, so it's really confusing, right? But it actually benefits the signer if they sign twice, if one of those is invalid, because then it's not a duplicate. So
Right.
in this case, the one from the universe, we determined was not a valid signature because that circulator date is from 2012, which is a long time ago. So that would not have been a valid signature in the universe. So therefore, the other signature is not a duplicate, so it's a valid signature.
Right. I should,
That's
sorry.
that's the last one we're talking
Right.
about.
Yeah.
I said it inversely. We're not using it as an additional invalid signature. That one will count.
Yes, Sandra, we've moved on from Sandra. That
Yeah,
one would
okay.
count under, now that we understand why staff rejected it.
Okay.
With regard to Sean, there's no indication of why this would be an invalid signature. And what we would include as well is that in the last example that we have, which is the next sheet that that Director Brader acknowledged in his remarks as well, is that there appears to be a duplicate that has the exact same sheet. As you can see by the Bates stamps, both of these sheets were counted in the universe. It is signed to the same date. One is considered valid, one is considered invalid. These are they appear to be the exact same sheets. So there'd be two things that would be going on here. One of those signatures should be counted as a duplicate. And then two, the inclusion of multiple of the same sheet in the sample skews the sample, drives down the validity rate, and drives down the number of valid signatures that the proponents need in order to get across the finish line. Now, that second sheet falls within the threshold of sheets that were counted in the universe. Director Brader indicated that there was an isolated example. There's no way of knowing if that happened once, if that happened multiple times, how many times that happened. But it indicates that the sample itself is also skewed based on these double scanned pages.
Go ahead.
Yeah.
Please.
I think for the benefit of people
Yeah.
in the audience who have obviously a great deal of concern about this, it helps, and it helped me when I started looking at this to understand that the sample doesn't identify, does not have the capacity to identify duplicates, that this is something, and the Bureau does not have the ability, but the challenger had, with the benefit of some programs, AI programs, that the Bureau does not at this point have, the challenger had the ability to identify duplicates, which resulted in a dramatic change in the Bureau's conclusion regarding the sample, regarding whether or not there were sufficient signatures. So when when you identified duplicates, the staff then had to go find the alleged duplicate, in this mass of papers or through the scan and look for it. It was, and the staff then had to make this determination about whether in fact it was a duplicate, which should be subtracted from the total. So I just, it's confusing. It was confusing to me initially. We had the sample, and then I needed to get my head around the fact that you look at the whole, that if you have the capacity to do it, you look at the whole universe to determine whether there are duplicates. And that's why the challenge was so different from the staff's original conclusion. That we look at the validity of signatures in the sample, but with regard to duplicates, we also look at the whole universe of signatures.
Certainly, and that's helpful context. I think it's helpful to contextualize that for the folks that are here today. I think that it's important to note, though, that the constitutional threshold for validity applies to the universe,
Of course.
not just to the sample. So it's important to make sure that those duplicates are recognized. And we didn't, recognizing your remarks from February about the importance of very robust challenges and providing information to the board so that they can vet it. And they have a Herculean task of vetting these petition sheets. We went through and identified line by line, both in the sample and in the universe, where those duplicates could be located. So we weren't sending people on goose chases. We provided all the evidence. We provided sheet scans, 54 pages of duplicates in our initial challenge. We contend, though, that the remaining 9, Sandra discounted, should not be considered valid, that those 9 must be considered invalid for the same reasons that our original duplicates were. And I think that this Sean Prude example is a good example of one that ought to be removed from the sample as well. And certainly with the example of Janelle Gardner, I believe, if that's not a duplicate, what is?
Question for Director Brader. Is this a scanning error or are one of these a copy?
So in this particular case, what we think happened is that we accidentally scanned one sheet from the universe twice. So when we're scanning those 10,000 plus sheets, this sheet got scanned twice. Part of the reason it takes a while to get it out to folks is we do quality control to catch things like this, but it appears we missed this one. So this sheet was scanned twice, which I mean, essentially, so this doesn't look like it was actually a duplicate signature. It looks like it was a signature that was scanned twice. So I would say it shouldn't be rejected as a duplicate, but it does mean that our sample in the universe slightly overestimated the total number of signatures in the petition. So we said there were, 581,000, whatever it was, 561,282 signatures. There actually were only, it overcounted that by 10. So there actually were 500, our staff report should have said that the total filing was 561,272 signatures, not 561,282, because the sheet was scanned twice.
If I may respond to that, this is a sample process. So this is most certainly a duplicate, because if it happened in one of these 1,000 sheets, that's supposed to be exemplary or a sample of the remainder of the universe. So this is a duplicate. It's a duplicate. And whether this happened, you can't say, oh, this is an isolated occurrence. I mean, we've identified that it's happened once. It technically satisfied the definition of a duplicate. We don't know if, so this is a representative proportional process, and we were able to identify this as a duplicate, which it is. And it should be properly removed and invalidate the sample signature.
I think it's also important to note, I haven't been able to read the proponent's response that was received today, but in our duplicate challenge, the proponent did not refute or challenge any of our duplicates as invalid. So these are ones that the remaining 9 that you have before you are ones that the staff has not explained why they have rejected, and the proponent hasn't attempted to rehabilitate them. So what we're asking is that this board act consistent with Michigan law and the Michigan and applicable precedent and knock out both dupes for those remaining 9. Do you want to move to the next one? We can go through those, and you also have them available to you. So the next one we have is Lakeisha Fisher, 81278, universe page 56986. Anthony Romero from Westland, signed exact same address, exact same city, exact same zip code, just 1 month apart. Indris Heller, sample page 89055. Sloan Swanson Basie is number 6. Sean Bowden, Jawan White, Linda Wan, and then last is Janelle Gardner. So I don't think we're asking the board to depart from any of the regular duplicates that you deal with in an ordinary petition challenge at this point.
So you're saying, okay, we're starting out with 657. And
Yeah.
you're saying take away 10 with regard to this issue.
9.
Yeah.
Yep.
Okay. Mhm. We address these so we can keep track of, count. Because obviously this is painfully close.
Yeah.
And every signature counts. So if we're keeping track and now, listening to the challenger, and if we say, okay, now we also need, of course, to have the petitioner respond to these. So I'm not sure the most effective way for us to keep track or to understand whether, I guess what I want to understand is whether the staff has considered the presentation or the argument of the challenger and made any different drawn any different conclusion regarding these particular duplicates?
Yes, we have. So I mean, I agree that it's going to be time intensive, but it probably does make sense to adjudicate each individual
Yes.
signature. So whether you want to hear from me on each of theirs and then hear from the sponsors, or hear from the sponsors and then go through them, it's up to the board. But I do think we'd have to go one by one.
We're going to walk through this and we're going to look at section by section. And there are signatures being questioned on every section for different reasons. This is exactly why we want to keep this structured,
Yes.
that we don't end up at the end of the day with soup.
Mhm.
But then I would also suggest there are three parties here involved in addition to the board. There are you folks as challengers. There is the Bureau of Elections as the folks who actually audited and counted and reviewed these signatures. But there's a gentleman sitting behind this that I can't see because Mr. Bradley has to have a seat at this table. And so I guess I'm open to my fellow board members here, but I would think that this needs to be a participatory presentation and process. Mr. Bradley, you're
Brady.
kind of hidden. Oh, I'm sorry. You know what?
You always mess up names.
I do that. You know what?
I don't want Mr. Brady to feel
Mr.
slighted.
Mr. Brady, will you please forgive me? Yes.
You nailed Kievsky, which is.
Yeah. Yeah, we won't go down that road. Mr. Brady, would you, there, now I can see you.
move this easel, but.
I think if we're going to have this discussion, we're going to talk about these in sections. Everybody has to be represented. Is that fair? Director Brader, does that work for you?
It works. I mean, there's no perfect way of doing this. I think,
No.
you know,
No.
both sides would probably like to give their full presentation. And I think the challengers were kind of halfway through their presentation or thereabouts.
Well-
We started talking about duplicates. I think they probably had other things they wanted to present on as well. So I guess what I would recommend is either let both sides do their full presentation and then go individually in more detail as we're going line by line, or just for the duration of, for the balance of the discussion, hear from each side on each issue by line.
What I'm seeing in the presentation is that we're in effect going down through the outline.
Okay.
I mean, I'd be happy if everybody wanted to do that. If you want to have your presentations already been made and you would make your presentation and then we start going down through the outline. But again, I'm going to go back to what I want to avoid. I don't want to have this become a day where there's all kind of noise flying around. And at the end of the day, nobody's quite sure who's on first and who's on second. These folks in the audience and these folks in the Bureau all deserve, along with the people of Michigan, they deserve the best from us. So in order for us to give that, we have to understand, and I think that this is a large piece. When I looked at all of the challenges and the responses and the staff report, I was up pretty late. Had to read some of it twice. This is a very complicated, confusing piece. And I think we have to take it section by section. So that being said, if we're going to have you make your presentation, your opening remarks, and then we're going to go through this, then I would say, Ms. Flowers and Mr. Doster, your team made your presentation, and now we would need the opening remarks.
Happy to cede the floor for that.
Are you okay with that? And then, by the way, let's go one step further, since it's 20 minutes to 12. We'll get the opening remarks from the other side, we'll get everybody on the same page, and then we can take a break and we can come back and finish it. Is that,
So,
And address each category seriatim, you mean?
I'm
By
sorry?
category. Yeah, yeah.
by category.
His question was, and then address each category.
Yeah,
as
I
a
think we
by
get the
category.
openings first and then we go back through the categories.
So when we talk about the categories, the July 21st challenge had 10 duplicates, which Ms. Flowers is just talking.
Mhm.
12 alleged fabricated addresses, 3 this, 3 that.
Mhm.
So, and Mr. Brady has presented us,
It's got a package here as well.
right, with something that addresses each of these 10 duplicates. And so this is really clarifying for
Maintains the
us.
same order and structure as.
Right,
That's right.
so, so this is very helpful and we are, yeah, doing this line by line because it is amazingly close. So so you have addressed the 10 dupes.
Yes, I think that the one thing that would be helpful as a baseline too is that if Director Brader, will we be removing the duplicated page from the sample? I'm trying to understand whether the validity rate has shifted such that I want everyone to understand the target that we're shooting for.
I mean, I think the board has to make that determination because we don't have the sampling process we use that the board approved doesn't account for the possibility of a sheet that was scanned twice. So, I mean, really what should happen is, like in a perfect world, what would happen is, perhaps it cannot do, is we would redo the whole sample, but that's not possible. So, I mean, Mr. Doster argued that it should be treated as duplicate because the sample is standard for the universe and this is a duplicated signature. I think most precisely, the only thing I can say is that the universe is 10 smaller than we thought it was. And so this signature maybe should or shouldn't be part of the sample, but some signatures should be sampled. And then the percentage of the validity rate needed should be very slightly higher than it actually is.
The weights are gonna be
May I
hard to
Yeah.
determine.
So I don't know how I would. Maybe we can think about that over the break, about what we recommend is the best way for the board to handle this double scanned sheet. It doesn't seem clearly right either to reject it or accept it, honestly.
My only comment to that is that this sample is representative of the universe. So if you're treating everything else as representative of trends, occurrences in the universe, this double scanned sheet should be treated as representative of the universe, not as a single occurrence. And I think the only way to accurately account for that is to treat it as a duplicate. So I know we can address that later, but I don't want to lose sight of the exercise that we're engaged in with regard to extrapolating across the universe. All right.
Sir, if you would give us your open, you could take your opening as wide as you want to, and then when we get done with that, then we'll come back and then we'll continue the outline with the dupes. How's that?
Good morning.
Good morning.
Good morning. Good morning, Mr. Chair and members of the board. My name is Michael Brady, for the record, MICHAEL BRADY. I'm here on behalf of Michiganders for Money Out of Politics, the sponsor of this petition. Just to clarify, this would be opening remarks, and then I believe what's intended is a
You
break.
make your opening presentation
Open
and then.
presentation, and then we'll
when,
afterwards go back and
then we'll
forth.
go back to, but then we'll make it interactive, so
Yes.
everybody's here at the same
Yeah.
time.
I think that approach makes sense. I'm joined by Sam Bagenstos.
Yeah, Sam Bagenstos, BAGENSTOS. I'm also representing Michiganders for Money Out of Politics.
Well, I appreciate the opportunity to speak with you today. It's certainly an exciting day. Maybe it'd be nice if it wasn't so exciting, but here we are. And among other things, as I've thought about this, as I was trying to explain to my 13-year-old, asking kind of what am I doing when I'm going to Lansing today and the like. I really believe this is an exciting day for democracy. I think in a certain respect, you see here today, both proponents and opponents in the audience waiting to give public comment, observing their government function. This is how the process is supposed to work. And maybe an old-fashioned idea, and perhaps folks would feel that used too often, dare say, some might suggest a cliche, but the idea that our government can be one, as the saying goes, of the people, by the people, for the people. I get it, but I really do believe that's the goal. And if we lose sight of that collectively, I think there's kind of a larger concern there. I also really believe that that is precisely what the framers of our state constitution were envisioning when they reserved to the people, the framers reserved this right to the people in Article 2, Section 9, the power to propose laws through initiative. What we have here today is the culmination of thousands of Michiganders, of Michigan citizens, Republicans, Democrats, and independents, exercising their constitutional and statutory right to reform their government. That should be celebrated. And I add, especially during a time when so much divides our country and our society. Under this board's adopted policies and procedures, MMOP needs 636 valid signatures from the sample. I'd like to think that's beyond dispute. It was noted on page 3 of my opponent's July 9th filing, their sworn challenge. They wrote the same, 636, or more, you must certify, 635 or fewer, you must deny. Subsequent filings have called that number into question, have called this process into question in a way that is concerning. Not simply the challenges as we saw, just get a little taste of just a moment ago, looking at line by line. And that's, I think, where the focus should be. But other aspects, perhaps, I don't know if it's a Hail Mary or otherwise, but other aspects, if they're down on the count, that maybe the overall approach is wrong. Maybe this number 636 is, if it actually were that, it's not, 657 for the staff report. That this board should revisit and rethink how it handles these petitions in the middle of this process. I think all of that's a distraction. It's not lost on me, it's not lost on you. A little bit of a David and Goliath situation here. Wear it with pride. But for you all, I ask that you remember that this board set a policy years ago. The practice used to be different. Some of you were here when it was different. Others may have served or had clients or other folks who engaged in this process before 2023. This was different in 22. It was different before that. And this board had a deliberative process that was open to the public, where they engaged attorneys who were regularly in practice before this board. I believe some of opposing counsel were part of that process. Their firm certainly was. Other folks, Christopher Bilcock, now on the now on the bench, but other folks as well, Mr. Liedel and the like. This board, during that process, engaged statisticians to reassess, to assess the existing process and to look for opportunities for efficiency. That analysis was then sent to other statisticians to make sure that it was methodically sound. They affirmed that. That was deliberative action taken between games, if you will, between rounds. There was no petition live then. That's why you timed it in 23 and not 22 in the middle of all of the different petitions that were up in 22. You cannot change your policy retroactively or in the middle of a petition cycle. It isn't right, it isn't fair, it isn't legal. And so I encourage you, no matter what else happens today with the individual signatures and the like, don't do that. Don't do that. PMFS focuses on the 41 signatures. We're going to get into that, I guess, after lunch, the back and forth. I provided you some of our assessments and, reactions to those. I look forward to that conversation. I want to add as well, there are 41 signatures and they point to, 657, 636. If you look at page 13 of the staff report, it says, and I quote, because MMOP had a sufficient number of valid signatures even after processing the challenge, it was not necessary for staff to process MMOP's response. Our response, made rebuttal attempts at 204 signatures. This isn't a question about, they have the burden. You all laid out a process. The law charges you with the responsibility to canvass these signatures. You did that by way of creating a process built on decades of sampling experience. You ran it by people who are lawyers, who would actually be involved in the arena, who had been involved in the arena, and who are involved in the arena. They were involved in the process. You ran it against statisticians to make sure that it was sound. That's how you've accepted your responsibility to canvass these signatures. And part of that process provided us the opportunity to rebut. And part of that process said it didn't make sense to spend staff time processing our rebuttal when we were already ahead. That's your process. It's on your website. It's what my clients relied upon. It's what you have otherwise applied in every single circumstance. And so, I feel very good about our responses to the 41 signatures. But I'm also pretty happy to have the 204 not yet addressed. And in all of their responses, challengers have the burden. The staff report, your process, the staff report is given deference. That's what the courts say too. You recall this, those of you who were back in 22. We won the staff report. Some of folks on my clients admittedly wanted to run up the score. They were upset that our rebuttal wasn't offered. Like, oh, only 21, there should be 221. I said, it's your process. We just followed it. And in all of their responses, we have responded in kind, addressing their concerns, rebutting their concerns. They've never responded to ours. And staff still hasn't processed ours either. So as we head into lunch and the like, I'll just say, remind you that your duty, what the day demands of you, comes down to two things. First, as MCL 168.477 sub 1 states, the Board of State Canvassers shall make an official declaration of the sufficiency or insufficiency of an initiative petition no later than 100 days before the election at which the proposal is to be submitted. That is Sunday. You all scheduled it for today. I believe this is the last opportunity for you to do it. I look forward to you, making that determination. But that's your duty. Additionally, the election law requires the Board of State Canvassers to approve the ballot language summary. And that's on the agenda, and I'm glad to see it on the agenda. And I would say one way or the other, bless you, one way or the other, I can, anticipate that, who knows, maybe opposing counsel and all of us will be in court. But including the ballot language summary regardless, I think is critical to allow this process to continue to play out, and to make sure that you all carry out that other aspect of your duty so that the director and the secretary can then do their duty in sending this to the legislature as the Constitution envisions. I'm not going to respond at this point to all of the various allegations and this or that, kind of address them as they come. But I did want to, as we're talking about dates, I did want to speak for a moment to the idea that my client somehow gamed the system because we gamed the system because we followed the law and the standards, the dates that you all put out. It's written in the law, it's 160 days. If you need 170 days, you should change the law. The legislature may very well be receptive to that. The rules were set beforehand. So it wasn't about ours. Or I hear you have an interesting one coming up next month. It's not about that one either, right? The rules are set in advance, so it's neutral as to the content. And we complied with that. We don't have all the resources to be able to kind of rush all these things through and do whatever else. My clients were working and volunteering and doing what they could to gather those signatures up until the very last day. That was a necessity. That's not gaming the system. There's a suggestion that we filed another example of gaming the system. We filed way more than was required. Your manual says a best practice is to file way more than is required. Why? Because of all these poster boards, right? I mean, and no disrespect, opposing counsel, those are the best of the best, right? But that's why you all and all the ones you've seen, you've experienced this. And you know, lawyers one week are coming back the next week on a different side of the argument. That's the game. It's not my client's fault that they filed more than they needed to, because that's both what you said and also the reality of the game. So, yeah. I don't know if you have anything. I don't know if there are questions at this moment, or, get right to lunch.
Vice Chair, questions or comments?
Yeah, so they filed a challenge on, oh, I can't, we have so
Their
many
first one?
papers here that okay, so the initial challenge was filed and you filed a response saying why their challenges were not meritorious. But you're talking about, so you're saying that that you identified 204 of their
Yeah,
challenge signatures, which were in fact valid signatures contrary to their assertion.
that's right.
Right. Okay, so 204. But all of their challenges were then reviewed by the Bureau.
Mhm.
So you have a disagreement with some of the Bureau's determination of their challenges. So I guess I'm not sure where this 204 fits in. I mean, that's because they say, and I'm a little puzzled actually by the statement that you cited, and the Bureau's staff.
In the staff report?
Because they say it was not necessary for staff to process your response, but your response essentially said your response challenged the challenges, and the
Yeah.
board considered those challenges.
Mhm.
So is there something that the board did not do with regard to your response? I guess that's a question that really is for Mr. Prater.
So, yeah, I mean, so obviously both sides can respond to our staff report and disagree with it. And so in the case of a challenge, the sponsor can respond to the challenge, which they did. And then also both the challenger and the sponsor can react to our staff report. So the sponsor might disagree with the challenge before we get to the challenge. They might also disagree with how we disposed of the challenge or how we otherwise made determinations on signatures. The staff report indicates, which is our practice, is that if we independently determine that the challenge is not taking the petition down below the required number, we don't spend the additional resources on looking at the sponsor's attempts to rehabilitate or to reverse our determinations and raise the valid signatures back up, because we've already made a recommendation. If after either our own review or the review of the challenge, the number had dipped below the required number, we would consider information from the sponsor, because that might take the number back up. So essentially, we're trying to get to our recommendation as efficiently as possible.
But I add something just in response to the vice chair's question. So I think, this is not the time for the line by line. We'll do that after lunch. But one way in which it would matter that the Bureau staff did not process our response to the challenge is there are some of the challenges for actually a fairly large number of signatures that the Bureau said they rejected the challenge because they had already knocked out the signature. had they considered our response in those circumstances, it might have been the case that they would have rehabilitated those signatures. So that would have increased our number, but it wouldn't have, affected their saying yes or no to the challenge. They said no to the challenge because they'd already done the work of the challenge there, essentially. So it might well make a difference. There are also a number that they rejected that it's very clear that we said should be accepted in various categories. But it does make a difference that they did not consider our response.
This follows along that line, and it has nothing to do with going line by line with the signatures, but in the staff report on page 13, I don't know if you folks have it in front of you, but it's the footnote regarding the validity level of the sample, which is admittedly very bothersome to me. And I would just like to hear your take on the fact that, if we do the math with the margin of error, we fall inside the margin of error.
So Mr. Brady may have more to say about this, but I will say it is inherent in having a process with a single acceptance and rejection threshold that there will be close cases, and close cases will necessarily involve a smaller margin of error. You before 2023 had a process that had an acceptance threshold that was above the rejection threshold, and then a pull more range between the two thresholds. And what the board decided, again, as Mr. Brady says, outside of the context of a particular petition battle, was that did not make sense to have anymore. It put too much of a burden on the staff. It put too much of a burden on people submitting and challenging signatures. And that if you increase the size of the initial sample from 500 to 1,000, you could get to a degree of confidence that would be, even if someone succeeded by one ballot or one signature in the sample, or failed by one signature in the sample, a degree of confidence that was sufficient to satisfy your obligations to canvass. If what you want to say now is actually, on second thought, we wish we'd done something different in 2023, that would be an appropriate matter to consider in revising once again the ballot sampling process. But this was a very considered decision that the board made in 2023 to have a single cut line, yes and no. And, I'll say even on the previous system, there was always the possibility that at the second step, someone might prevail or fail by a single signature. And here we have a wider gap than that, but I'm saying, the absolute limiting case. So I think you can't change the rules in the middle of the game, as Mr. Brady said.
We are not going to change the rules today.
No.
We are working with what we have.
Bless
We are working with the universe, or I'm sorry, with the sample as it's been laid out in the staff report, as it's been laid out in the challenges, and as you have given us, Mr. Brady, in the response. That's the walls of where we are today.
Absolutely.
So, yeah, we're not gonna go outside there.
We
Absolutely.
have enough inside to,
Yes.
I don't want to go out.
And I think that is the answer to the margin of error question.
To ignore it? Is that
Well,
what-
the answer
Built in.
is the sample, what you have determined is that you have a high enough degree of confidence. And I would reject the suggestion from our opponents that the standard is certainty. The standard is, first of all, there is nothing that is certain in this world. Secondly, as the Michigan Supreme Court has repeatedly said, most recently in the Mothering Justice case just a couple of years ago, this is a process that is designed to promote the interest of the voter in protecting the voters' reserved lawmaking power, the people's reserved lawmaking power. And so the question is there a sufficient degree of confidence? And what you all determined in 2023 was a sample of 1,000 with a single cut line means that if someone is above the cut line, then you have sufficient confidence. And that's the only standard we're arguing for here.
That's where we want to live today, too.
I agree that it is confidence and not certitude. And that's specifically stated in our, in the sample process that we adopted, that this would give us 90% confidence level, that we had, that the appropriate level of signatures had been reached. So. Well,
All right. Are you, we're in a happy place?
Thank you.
I don't know what the plans are for the Bureau for lunch. Are we okay if we break now?
Yeah, we have lunch upstairs for you if you want to break now for whatever time you think is
Does,
appropriate.
I guess the question I'm asking is this timing breaks? Is this timing work out for you or is?
I think so, because my understanding is we're going to get into individual signatures, so I think it would be disruptive to start one and then, have to stop. So, I think we should break. I mean, I think now is a good time to break.
You hesitated there, would you?
No, well, I may have hesitated, but I still think it's a good time to break.
Excellent. Perfect. That being said, we are going to break for lunch and if we're back here by 5 after 1, does that work for you? Gives you an hour? Thank you. Thanks for all the cooperation this morning.
I thought that I had lost my, but I
I hope you all had a nice lunch. Are we ready to continue? As we go forward here, we're at a point where we talked about having everybody represented, right? Mr. Doster, you and your folks, and Mr. Brady, you and your team, and Director Brader. So the model is that we will walk through the structure, the outline, where we'll pick up where we left off with the Duke conversation. And the plan here would be to continue to go forward. I'm sorry?
one signature at a time.
Well, one signature at a time, certainly one section at a time, and to work our way through this. The Bureau is going to keep a running total of where we are here. You may complete your presentation, but again, we're, however you folks would like to have it, you're both invited to the podium. How's that?
I think you can bring additional chairs up if you'd like. I hope I'm not violating a Senate rule there.
And you will need to turn your mics on.
Yep. Okay. There are some groups that we will be able to do sort of as a group by group. Duplicates is one where it really kind of have to go through it one by one, if that works for the board. Okay.
Mr. Brady, could you turn your mic on as well, sir? Thank you.
Yes, thank you.
So as we said before, and we can skip through the first one. I don't think there's any disagreement about the treatment of dupes. It's just a matter of whether the second one in this case is valid or invalid. So if you have Exhibit A, that is the combined sample sheet, universe sheet for each of the 10 duplicates that we contend that the staff report got wrong. So Sean Prude, this is the sample sheet. It's got the blue dot. No concerns that this sheet is invalid, but could we go to the universe sheet, Shelby? Thank you. This one, we see no reason that this wouldn't be a valid sheet. The corrected number is in the date would be consistent with corrected numbers as the staff determined them in the staff report. This appears to be an otherwise valid sheet.
And to clarify, when you say corrected number, you're referring to the Sean Prude's signature on line 8 or a different corrected?
Nope, I don't see any other corrected number.
Well, I mean, the one that's to my mind clearly corrected is in line 1, which is not in play, obviously. So
Oh, yeah, no, we've highlighted the ones that are.
yeah,
Yeah.
So it wasn't, I think when we were looking at this, it wasn't clear what the signer's date was that looked illegible to us. And so I agree that people can correct it. It wasn't clear that they did in a way that was legible to me. So that is, you know,
This should be.
I think we were trying to understand why the Bureau came to the determination that it did, that in rejecting the duplicate because the other duplicate is invalid for some reason. I think for all of these, we could go through, you know, for each of them, I think opposing counsel has made clear they don't understand why. And I can offer responses to what it might be. It could also be other things like the Bureau's review of the qualified voter file or other things along those lines that are part of the process. And so I don't know if it makes sense. And I noted that as you saw in my response. And so we were relying on the staff report here. And so if you want me to kind of take a guess at it each time, then I can offer that. But my guess from what I can see is that this was based on the illegibility of the signer's year, the year, you know. But I'm very curious to know the staff's reasoning.
In this instance, staff determined that it was not a duplicate because the signature in the universe was invalid, because staff determined that the last number there on the line 421-2, that was an 8. So staff determined that was 421-28. Therefore, staff determined that the universe signature was invalid. Therefore, staff determined that it was not a duplicate.
So that tracks with how we had seen that as well.
We've provided the sheet there for the board. And you can see it on the screen. That's clearly a 6. And if that is not a 6, then there's a number of other corrected numbers on these sheets that that our date challenges were rejected for, that we would take issue with.
And I'd also note opponents in their challenges have challenged dates for something that is less clear than what appears to be the letter B. Doesn't make sense in the context, mind you, but I can understand why staff thought it was an 8 because context suggests a number and not a letter. I don't see 6.
I think it's also a bit of an odd posture here because the presumption is that a signature line is valid, right? That applies equally to the signature in the universe as a signature in the sample. And we've taken our evidentiary burden to try to present the information that we have to you to prove that certain signatures within the sample aren't valid. But in a situation like this, where the signer has clearly corrected their number to a 6, the presumption is that it is valid.
With these types of determinations, I mean, obviously it's a judgment call. Staff determined it was an 8. It's the board's decision what that number is, if it's legible, of course.
Comments? Are you calling it a dupe? 4 days? It's coming. You got a dupe.
All right, moving on. The next one we have is Lakeisha Fisher. This is the valid signature in the universe. I don't think we need to spend too much time on that. Next one is the universe page is 56986, row 5. Signature or paid signature gatherer box is checked. Signature date matches the circulator date. All the information appears to be there in the circulator. Everything otherwise matches the signature line.
So for this one, I direct you above to the county, and I can't read what that says. And my suspicion is that might be why the staff found this to be invalid. If it's not, then they have another reason in addition to this. I suggest that is a no county and or illegible.
So this is a Flint
Maybe
sheet.
gumbo? I'm not-
Again, this is a Flint sheet. It says Genesee in the county. And as far as you need all of the S's and all of the E's, we lost 3 challenges in the challenge process for creative spellings of Genesee. So to the extent that the board thinks that that's indecipherable, messy handwriting, misspellings, the board and the staff report determined that those were valid.
What I would offer, we stand by our assessment, which is drawn from your policies in your manual on your website that says that messy handwriting and misspellings are not cause for something to be invalidated. When it comes to Genesee, it's one thing that, all the E's, all the S's. I don't see an E and I don't see an S. I think that is, again, had to guess, it does look like gumbo to me. I'm willing to grant a G at the front. But again, we can now turn to staff perhaps and ask them why they thought this was, maybe there's a whole nother reason. So I think I give a pretty good one.
Am I up? So yeah, we thought it was illegible. So it is true that we do not disqualify based on misspellings. Now, obviously, each misspelling is a little bit differently. So if we were dealing with a misspelling here, there could be a debate about like how close it has to be to Genesee. And there's obviously an infinite number of possible misspellings that the board could determine, but in this case, it wasn't a spelling issue, it was a legibility issue. We determined that that was not legible as a county.
So I would urge that
I don't see that one, kid.
again,
You see-
messy handwriting in the context of a duplicate.
I can make the connection between seeing Flint and looking on the top of James. Yes, I can. That oh, sorry. That with that in a bubble, tough to make out Genesee. Me looking at Flint and looking up there and seeing Genesee, I could make that out looking at a sheet full of Flints, but
You're looking at Flint already filled in.
correct.
I mean.
Yeah, no, understood.
They tell it's Genesee because a lot of these are Flint at this.
If I look up there, I see, okay, obviously that, I see a G, I see the E's. Yes, I mean, I see, but again, if I'm looking at that, if the sheet is blank, I would certainly have a difficult
I
time.
have no idea if the sheet was blank.
And that's not how the Bureau reads a signature line for illegibility, is it? They look at what
Director-
they can read.
Director Brader, if the Genesee is illegible, then the petition sheet is not valid, right?
That's right.
We have,
I would say that it's Genesee because because these are Flint addresses, but it is illegible.
But the point being is that before there was a Flint address written on here,
It was still illegible.
it's illegible.
Right, so that means it's
My-
not a dupe.
My one final comment would be that you have to look at this sheet, right? Would you invalidate 5 signatures on this sheet in a different, looking at it ordinarily for the way that they've written Genesee?
And I would offer that based on the 4 different filings of my opposing counsel, they would invalidate 10 signatures based on the signature. In fact, they've offered various attempts to invalidate the signatures of 10 Michigan voters based on less. So I'm maintaining the consistent posture, and I just want to point that out.
Okay?
Not a dupe, okay.
Where it is?
Move on. We can move on.
All right.
All right, Anthony Romero.
Oh, sorry.
Oh, sorry.
Did the board determine that that?
Oh, sorry.
be a
Yeah, no
dupe or
dupe,
Not
no
a
dupe.
dupe?
No. No dupe.
No dupe? Okay.
Anthony Romero. That's 88682 within the sample. And then the universe sheet 102860. This one, they've got the paid signature box checked. They've got the entire line filled out. I won't speculate here as to why the second one was not found to be valid.
We'll
Oh,
give,
sorry, could you move to the universe sheet?
yeah, thank you.
Thanks, Shelley. Perfect, thanks.
So, given the exercise, I believe I'm, required to, or at least have an opportunity to speculate as to what the staff was thinking when they found this to be invalidated. From our review, it appeared to be different handwriting, different signatures, same address. And so we were wondering if they're in fact different people, perhaps a junior and a senior. I'm a junior, so it's a dynamic that I'm familiar with. But I now defer to staff.
So the sample signature matched the signature in qualified voter file, but the universe signature did not. So we determined the universe signature was invalid, is an invalid signature. The board is welcome to look at, we have the QVF signature pulled up if the board wants to review that. Unfortunately, that's not, well, fortunately from a privacy standpoint, but unfortunately for others, that's not visible to anybody else. But if the board wants to look at the QVF signature, they can. But the board, the staff did determine that the universe signature did not match. So therefore the universe signature was invalid. Therefore it was not a duplicate.
So you left this as not a dupe simply because the universal signature was invalid.
Right.
Signatures don't look the same to me.
I would note that for the first signature, the individual has written out their, it appears to have written out their first name, and the second one, they appear to have abbreviated it. The first signature, it appears that the signer wrote Anthony, and the second signature, they appear to have written A.
The universe signature is just a kind of a scribble, but
You say you have the
no,
signature?
neither are very legible, but they're not the same. That's, I think, the significance for me.
In signatures, according to your policies, the signature does not need to be eligible. It's other information on the sheet, which then allows your staff to check the QVF and compare against the QVF, which is what they've done. Forgive me, Member Cordes, I believe I heard you ask if the signature
Yeah.
was available, and it sounds like
it-
you're available to
Yeah.
you all.
Yeah.
but
Can I
not
see
us.
it?
You would like to see the signature, yeah.
Can you show that?
But the,
You want
I would suggest looking at both signatures.
to take in?
Because the first, well, we're assuming that the first one matches the QVF. We don't
Well,
know that.
I'm
The
not
one
sure
in the
we
back.
are, didn't. Well, we could look at both of them.
Yeah, that's what I'm asking. I'm suggesting that.
Isn't the relevant consideration whether they,
If the signature in the sample had not matched QVF, we would have rejected that for that reason. But we have it pulled up if you want to look at, you can look at the signature yourself. Yeah, right.
Thank you. You're right.
I was gonna bring a magnifying glass. I just.
Oh, my goodness.
I wish that wasn't so spot on.
That's what it feels like.
Yeah.
Our conclusion, it's not a dupe.
All right,
Okay.
Yes.
move on. Okay, the next one we have is Indris Heller. So this is the valid sample signature. And then 87431, row 6 is the universe signature.
Like the same Genesee issue.
I had also had a question on the Genesee issue and wondered if that was perhaps, what was in play. There also appears to be ink on the summary, and so wondering if this was a damage or MRE issue, but I turned now to staff. I don't know. Unless you wrote that on. Oh, right.
Sorry, was it my turn? Okay, sorry.
I'm just
Um,
speculating.
So for this one, there's the,
One-
Genesee is, I think, a bit more legible on this one, still a judgment call, obviously. But what we were looking at actually also is the date of the circulator block. That date being illegible. So staff determined that the year, I assume the year was not legible. So I mean,
W?
if staff determines, or if the board determines that both the county and the date are legible, then this would be a dupe. If the board determines that either one of those are illegible, then this would not be a dupe because the universe signature would be invalid.
I say the Genesee is clear on this one. And I have no problem seeing that that's 4/25/26.
I would take this one as a dupe.
Agreed.
Okay, apologies.
Sorry.
We're still looking at this little squiggle for the 26, but
Clear that
it's gotta be. I mean,
it doesn't look like
It's-
26, but it's.
so it's illegible. The year is illegible, is
Right.
what we're saying. But this is where we get into the super pickiness. Yeah, I think it's a dupe.
Yeah. I mean, I know I've written them.
Is that a dupe?
It's a dupe.
All right,
Again, we got a dupe.
Please don't deadlock on anything because we have to figure out what that means.
Okay.
She give us things with 3 sheets, Director.
okay. So for 95251, that is, apologies, I'm skipping one sheet ahead. For Shalone Swanson Basie, the sample signature is 89162. The universe signature is 95251.
The concern that we identified with the universe signature at 95251 is in the circulator area, it's the date it appears to read 2020.
That's what we found.
Yeah, it does.
So
Zoomed in, I think. Yeah, thank you.
Mhm.
2020?
that is not consistent with the other 0 that's on the same line.
Be that as it may, it doesn't look like a 6
No.
to me, which is the standard, I think, so.
That has the clear marking of it has the same loopty nature.
I mean, I can see that that's like, I could see the 6 there. Like that, it doesn't look anything like the 0. And if you look at some of their other writing,
The other people are not writing there.
Yeah.
no, I'm saying even on on like the address.
Yeah, and to that, I direct you to the complete residence address, which appears to say 428. If anything, if it's not 2020, then it might be an incomplete 2028, but I don't see 2026. If you want to zoom it in again, you can see like the very kind of curve at the top of those two.
Right, that doesn't look like a number.
It doesn't look like a number, no. Doesn't look like the 8 is cut off.
As
I would say it's not a dupe.
I would
Circ-
disagree. I think it's a dupe.
Okay. so
Go with the dupe on this one.
Sorry, what?
You knew that would happen?
Yeah, are we deadlocking?
We probably are.
So we have to figure out
No, if
what
we're
it,
gonna do that, though, it has to, we can't change it if we're deadlocked. Whatever the current status is stays. We can't break rules here. Is that,
Board's determination stands unless we disagree with it, is what you're saying.
I mean, if we're gonna deadlock this way, we're gonna deadlock we're gonna follow the same rules that we would follow if we were deadlocking on a petition or on a, you're looking at me cross-eyed. Is that the right approach, Heather? Oh, I'm got a different plane, okay. We're going to deadlock on some of these, so
so it may not matter.
Right.
So why don't we note that the board deadlocked on this and we will spend the
keep moving.
brain power on that if we need to.
That works.
That's number 6. Right?
Next,
okay.
what's that? I promise.
Okay, next we have Sean Bowden. That's the universe signature, and we can move on, or sorry, that's the sample signature. We can move on to the universe signature, 83192. Again, we won't speculate as to what caused the Bureau to determine that this was not valid.
And on this one, I don't know, the squiggly 26 and the circulator, I don't know. I'd look to the Bureau.
This one, staff determined that on the signer row, staff determined that it said 8/6/26 rather than 5. So that's really, I mean,
Oh.
for the board to determine, obviously.
It's 620.
That very much looks like a corrected 5.
I think it looks like a corrected 5.
Agreed.
Here's-
This
So-
is a dupe.
This is the difference.
Got a dupe.
Okay. Juwan White, his sample signature is 108-734, row 9. The duplicate page is universe page 61523, row 8. I'll reserve judgment and would love to hear the Bureau's thoughts on why this was a duplicate. Well, this was not a duplicate, rather.
Yeah, and the reason we didn't think it was a duplicate is that it's potentially two different people. There's a different address, different handwriting. One is at 12685 Kentucky, and the other one's at 13109 Indiana. That is our suspicion as to why these are not actually the same person, but simply the same name. And we similarly look to the Bureau for its assessment as to how
Different people.
different people, exactly.
It could,
It's just not a duplicate.
but I would note that the signatures appear identical. And
don't-
as
yeah.
we'll get into in the registration discussion, you're allowed to move. So,
Yeah, they don't look identical to me, but ultimately the standard, of course, is comparing it to the QVF.
Mhm.
And so we'll look to the people who have access to the QVF.
It's not a dupe for me.
No, it's not a dupe.
No, not a-
Okay.
Not a dupe.
What was the Bureau's rationale?
good point.
I'm just curious what the Bureau, why,
Yeah,
why,
trying to
why
figure
was
that
it
out too,
disqualified?
actually. I don't know if it was because two different people or because of a legibility issue on the weird. So in QVF, these two records are actually purged. So indicating that it is the same person who moved or otherwise had a duplicate registration. The date of birth is the same. So these are likely the same person. I think that the staff actually I think the staff was actually looking at the date. On the signature line on the
With the circulator?
do yeah, I don't really see. I think they were looking at the date line on the signature in the universe, but I don't really see an issue there.
I also, I don't think the signatures necessarily look identical, but if you look at that J and even the W, I mean, those are very similar signatures. Those are not two drastically different signatures by any stretch of the imagination. That J looks almost identical. If
Yeah,
they are merged into the same file, this is the same person. One could very much see how those signatures would be coming from the same individual.
I haven't changed. No.
Okay.
So but I do think it's important that we have the new information from confirming from the Bureau that this is in fact the same person.
I'm sorry.
But I do think it is compelling that the Bureau has confirmed that this is in fact the same voter file. Given that, would the board take up a motion for reconsideration of their vote on this signature?
Didn't we hear the director just say that they don't know why they?
Well, yeah, the issue, I don't know if you heard, we already voted. So
But maybe,
I understand. I'm just saying. You're
I think
skipping an
we-
important part.
We made a conclusion and
Right.
then it got kicked over to Bureau to look and see, is that
I
in,
think that Member Cordes thought that our conclusion needed also to be informed by the Bureau rather than
correct.
just.
You are correct.
Yeah.
So. In which case. we could say,
What, the Bureau has looked at, is this one individual in the QVF? Is that what I hear you saying?
yeah, as far as I can tell, it is. So I think the board, I'm sorry, I was kind of distracted, but I think the board was thinking they maybe were two different people, which is why I thought it wasn't a dupe, but it looks like it is the same person based on QVF.
You're saying it is in fact the same person? Okay, then call it a dupe then.
Okay, it's a dupe.
Okay.
All right.
All right. We're getting to the end. of this section. The next one is Linda Wan, and that is sample signature 90366 and universe signature 52315.
Is the reason on this one because of the circular block?
Yeah, the staff determined that that said 2020,
I think it,
2020.
Shelby, would you zoom in, please? Thank you.
I can see that as a 6.
And it looks nothing like the 0.
Oh, but I see, yeah, I see the end, I see the tail of the 6. And that's,
But it doesn't. It has to have 2 numbers there.
look at this, look at the blow up there.
No, it's, okay. Oh.
I was looking, okay, so at the universe. which-
I
Right.
believe this is
You
the
were
universe,
looking-
right?
Yep, this is
Yep.
the universe.
Yeah, it is.
You were looking at
This,
right. They're looking at. This is why the Bureau, thought that was a 6. I
We
mean,
thought it
it's
was
a 0.
I thought it was a 0, yeah.
Yeah.
doesn't look like a 6.
Like
There's
a
a
Q,
second
I
sheet that
think.
you can blow up on the date. You don't.
Pardon me, could you
There's
repeat?
2 sheets involved here. You blew this one up and we can see that that is a 6.
Yes.
What about the other sheet? Can you blow that up?
So this one, yep, this is the valid signature in the sample.
No, 6.
And I would note that, 6 that the Bureau considered a 6 on the universe sheet or on the sample sheet in that case.
Those are 2 different circulators, obviously.
True.
Right.
Just look.
I think the, it looks like a Q. I think that's the thing, is that 6s don't usually kind of round the full circle. Like a 0, which does.
I'm picking it up as a 6. I agree. It's terrible penmanship, but that's a question for a different day.
Yeah.
Uh,
Just need more investment in our schools, I guess.
Confirming for me what a difficult task it is
It is very hard.
to check these signatures. And it's going to be worse when people no longer learn how to do cursive.
Well, that's our,
Clearly,
clearly
we're gonna, some people clearly didn't learn how to do it in the past. So anyway, that's an aside.
I would vote dupe on this one.
Okay.
I would vote dupe.
Dupe. Or
And our last one is the Janelle Gardner issue. The double page.
Which I'd like to have an opportunity to speak to. I didn't speak to this earlier. Unlike any of the other challenges that are made, and I'll specify the valid challenges, like, of which there were many, and we didn't, attempt to rebut every challenge. If it's a circulator's mistake, if a signer makes a mistake, we have an opportunity as the sponsor, my client has an opportunity as the sponsor of the petition to go through, and in fact, they have gone through, and you see that they strike out individual lines where there's some sort of concern so that you don't think about it, that's part of the process, all of that. So if there's a signature or a circulator sheet or something that has a legitimate, invalidating aspect to it, 561,000 signatures is a lot, but, my client had an opportunity to do that. This sheet is different. This sheet is plainly, to hold them side by side, it's exactly the same sheet. And that is not in any way the fault of any of those signers. It's not the circulator's fault, and it's not my client's fault. And so while I understand and appreciate the very significant task that's before the staff, I don't think that the law allows, and I don't think basic tenets of fairness allow that be held against the voters on this sheet, or that the idea that they signed twice, when in fact they haven't. If they had, I think my opponents would be, including them in other ways to make that point, as we've just gone through here and as they've detailed through their, more than 100 different allegations of duplicates. This is an administrative error on the part of the state.
Sheet.
This is the Bureau entering in the same sheet twice,
Yeah.
correct?
Yeah, the same sheet got
Yeah.
double scanned.
And in fact,
But it's not a duplicate.
well, I mean, if the standard is someone signing twice, the person signed once. It was scanned twice, or scanned something like that, right? It was scanned twice, but
Twice signed.
but the standard is signing more than once.
Right.
And they've only shown evidence that they signed once.
Not a
And so
Not a
I really appreciate that there's questions of, does that shift? Yeah, I think Director Brader mentioned earlier, it may take the overall count from, forgive me, 561,282 to 561,272. And, whatever that means or does. But it's not a duplicate, whatever else it is. It's not, the signer didn't sign twice. There's no evidence of that here.
I agree.
Got it.
I agree.
Got it. Got it.
I'm on board.
Okay, but here's why it matters too, because what the board will do is that you'll take your final validity percentage and you'll multiply it by the number of signatures and you'll get your total and you'll say, did they meet the constitutional threshold or not? And what this is evidence of, and the fact that it appeared in the sample and appears throughout the universe in our review of the universe, is that you know that what that total number is not right, because you have sheets that have been double scanned, enough so that it impacted the sample. So whether that means you toss both out, whether that means you treat it as a duplicate, it's an error that skews your results.
But this
And that
can't-
has to be
we-
accounted.
We can't remedy this as a board at this table. This, you know what, it is what it is. For today's exercise, this is what it is. Okay? We can't fix this here.
I am also interested to see if that would be the Bureau's approach. If it's still just remove the 10, or if it should be representative of the larger scale of the double scanning within the universe.
Director Brader, if you'd like to comment on that, feel free.
My first suggestion would be, before we discuss this too much longer, to table it, because again, it might not matter. But we can make a note of it. So if this is the only double scan sheet in the universe, it really is not going to affect the validity rate in any meaningful way. Unless maybe if we're down to like one signature, it will. But I obviously cannot promise you to like a religious certainty that this is the only double scan sheet. I don't. So there isn't a specific mechanism. We obviously don't have time to redo the whole sampling process. We could, the only thing I can think of is just randomly draw some other signature to review, but I don't know that that would necessarily address the challenger's concern. So I'm not honestly sure what the best way of dealing with this would be. I think probably the best course of action would be just to reduce the validity, or the slightly increase the required validity rate and the estimate. But I think my bigger recommendation would be to table this, because it may not matter and it's probably going to engender as much time as is available for discussion.
We're happy to move it to the end if that is the approach that you'd like to take.
Say again.
We'd be happy to table this and bring it up again if it's determinative at the end.
Good with that.
Yeah, that's fine.
Yeah, if it's an issue, we'll have to.
So that concludes our presentation on duplicates. Do we want to do a check-in at the end of every section to make sure that everyone's on the total?
Is that the question you're asking?
Not in those words, but yes.
So we started with a validity number of 657. The board accepted 5 as duplicates, reducing that number by 5. They rejected 2, they deadlocked on 1, and we have a hold on 1 until the end. So the current number is 652.
652 with one, 650 with an asterisk, in other words.
652, there's one that the board deadlocked on that we have to decide on whether that would take it down another. And then there's the double scan sheet issue.
Yep.
That's 8. Oh, that's right, 'cause we had 9.
The very first one was conceded. You guys
Mm,
conceded that
yep.
this morning. So
Okay.
you pick up 5 dupes, the overall
Mhm.
number is reduced by 5 when it's deadlocked. Yeah.
Okay. All right. The next category of challenges we would like to address is the invalid addresses. This is one where we should be able to start out at sort of a high level, what the board's policy will be, rather, and apply it throughout rather than going line by line. But we raised initially over 30 challenges regarding a curious pattern that we noticed in our review of the petition, which was folks making up addresses that don't exist. Not just transposing numbers, not omitting part of their street address, making up numbers. So whether they don't want to be on a list, whether they don't want to get junk mail, whether they don't, we can speculate all day long, but we don't know why they did this. But after the challenge, after the Bureau reviewed the challenge, we had a total of 12 of these lines that have addresses that just simply don't exist. And so what is the standard in the Michigan election law? You need to provide your street address. It doesn't say that you need to provide your address of registration necessarily, or your residential address. It says street address, although there's different interpretations of how the board reviews those. What we have here is just simply addresses that don't exist. So the Michigan election law says that if an elector does not include his or her street address or rural route on the date of signing the petition as required under subsection 1, the elector's signature is invalid and must not be counted by the filing official. Like I said before, you're not required to have it be your address of registration or your address of residence, but it must be a real address. An address is not just a combination of letters and numbers. It can't be 123 Unicorn Boulevard. It needs to be a real address. It must denote a place. The staff report claims that the board has approved the use of wholly fabricated addresses on petition sheets. And after reviewing the 2023 manual that you approved, and after reviewing the memorandum provided by staff, I don't think that is what this board approved when you approved the 2023 manual. That was a Bureau document that may have informed your review, but there's nowhere that we could identify where this board has approved the use of made-up addresses. In fact, we had a prior staff report where Director Brader determined that a non-existent address was invalid as a street address. We included the quote and we included the exhibit in our July 10th or July 21st filing. But the quote was, additionally, a number of the petition sheets you submitted indicated in the header that your address was 3045 Longcrest Southfield. 3045 Longcrest South is not a street address in Southfield. Because 3045 Longcrest is not an address in Southfield, all the signatures affixed to your petition sheets bearing that address are also invalid. Now that was based on 544C2. If you're thinking, well, that's a heading issue, not a signature line issue. The term is the exact same in the statute, and the courts have said, and it's a presumption of the legislature, that if you're using the same term in the same statute, it has the same meaning. So what we pose to you is that, number one, the contention in the staff report that whether or not the address has to be real is entirely irrelevant is not actually the case, both under the plain language of 544C and the Bureau's prior historic practices. So again, we have 12 signatures in this category, where They simply do not exist. And I think it's important to think about how this impacts petition gathering moving forward. If people do value privacy, that's understandable. But the idea that you could receive entire reams and sheets of petition sheets where people no longer provide you with a valid address, that's an untenable path to go down in terms of the work that the Bureau has to do, in terms of the gravity of the impact of these petitions that you review and put these questions to 8 million voters.
We walk through this batch.
Did you want to respond?
Very much so. Thank you.
Yeah.
So I certainly understand the logic behind opposing counsel's argument. I disagree with the read on the law, and not entirely surprising there. But I would direct you, as I have in my other correspondence, to the staff report, and that the staff report addressed this specifically. So this kind of centers back to the very opening statement I made about let's not change the rules in the midst of this. In the staff report, 2023, it says in bold, they make it bold and they, do that for emphasis. And it says whether or not the address provided is a valid address. Not my words. Their words as you adopted them, or, your predecessors on this board did. And, opposing counsel read to you prior language from this board, from Director Brader about a street address in Southfield. That was from 2022. The same page, I'm looking at page 9 of opposing counsel's July 21st letter to this board, page 9, where it, really gets into the meat of these issues. Site 20, Exhibit C, from 2015. Site 21, Exhibit D, that was just what opposing counsel had read. It's from 2022. Site 22, it's from 2010. So I think it is both, frankly, it's not relevant what the standard used to be. You all were involved in the process. You had a deliberative process. You changed your rules. You did it in 2023. And opposing counsel is attempting right now to change the rules that exist for this process in the middle of this cycle. Should the rule be, what it currently is by your own staff with the memos that they sent to you all? Or should it be a rule that, existed 4 years ago or 20 years ago? I don't know, doesn't matter for today. It is improper to change the rules in the middle of the standard, in the middle of the process. If you want to revisit this, you can. It's not a bad idea just generally after every cycle to look at things and see what worked and what didn't. Maybe you add this to the list. That's the right time to engage the question, regardless of how you come out with it. It's not right now. My client relied on the standards and policies and procedures that were put forward that are on your website. Your staff applied, they sent it to you, they have it in bold and all those things.
Mr. Brady, are you referencing the March 20th or the March 20th board meeting?
I believe that is, yeah, I was referencing directly the staff report, and it was referencing the March 20th signed Board of State Canvassers draft minutes.
That was actually a question I was going to ask as well. So that's why I interrupted you. I apologize. When I read through that we had as a board approved the validity of non-existent addresses, I guess that I was going back and I realized that I'm, getting quite elderly, but I still remember most of our meetings. I don't recall that. I recall getting rid of the RAT code. I recall going through a number of long conversations about manuals. Refresh my memory, if you would. And Vice Chair, you were the chair at that point. Do you remember the? Mid-
Blaming me.
No, no, no. Stand up and be counted. You were. Um,
Uh,
do you remember us approving
I don't
non-existent
remember
addresses?
Specifically
Um,
that language, but I am looking here.
To
the
see where it is?
signature coding that we approved at that time.
Okay,
We changed the
we did, yes.
signature coding.
And we do not argue with the way that that signature coding says what a registered address is. But when you review the board meeting minutes and you review the manual and you review the coding, there's nothing in there that says you can use an invalid address. You can be there. There's plenty of examples throughout where you're registered in one place, you put down another address in the jurisdiction. That's a valid address. But that these aren't addresses in the jurisdiction. They're made up. And I think that that practice is not something that, I don't think that changes the rules. I think that's something that is consistent with both the text of the statute, which this board must comply with. The interpretation can't contravene the plain language of the statute.
And
Operator,
oh.
can you tell us what the determination was made with regard to this first one? What did you, that, Christopher Bracy, what did you? Was he registered at another address in the jurisdiction?
Yes.
And forgive me, all,
I'm
sorry.
looking at our codes. And if the person is registered at an address on the petition or registered at another address, that's okay. So if the person is registered, if Mr. Brazy is addressed at registered at another address, doesn't matter what address he put on.
Well, I think that's our argument, that we agree with you that if you are registered at another address, then you're registered. But these are not addresses. These are a made-up combination of numbers and letters. If they put down 544 Unicorn Boulevard or another made-up.
What I'm asking
Yeah.
Director Brader is whether Mr. Brazy is in fact registered at another address.
Yes, we determined that he is, well, at the appropriate time at least, was registered at a different address within that jurisdiction.
You have this individual pulled up on QVF there? Oh, you are, okay.
Mr. Brady, you.
thank you. There was reference to, the March 20th meeting and all these other things. I'll note that the staff report quotes the March 20th, 2023 signed Board of State Canvassers draft minutes. Your minutes are an official document that you're obligated to create under the Open Meetings Act. You're a public body, of course, you know this, you're subject to the Open Meetings Act. That comes with formal responsibilities. You otherwise carry those out. One of those is to have minutes. It's to have draft minutes by a certain date laid out in statute. It is then to have formal minutes that are approved by the board by a different date, explicitly laid out in the statute. That's, what happens, in discussion can be interesting. It might be illuminating for future conversations. But the official action of the board is the action that happens in votes and then is documented as required by law in the minutes. And so that's the right document to cite. And he does cite it. There seems to be a question as to whether
You have that document in front of you?
I have the staff report. I think it was included, it was attached to the staff report. I can offer this back to you. It's the very same staff report you got from Director Brader.
Mr. Doster,
If I may, what Mr. Brady just told you is not correct. He indicated that the passage from the staff report that's quoted by staff was taken from your board minutes of March 2023. They're right here. That's not what the staff report quotes. I was there when Chair Gerwitz and Vice Chair Hauskamp, I was at that meeting, and what is quoted by staff is a February 2023 memorandum where this board took rid of or eliminated some of the challenge codes and added others. One of the challenge codes that it did in fact remove was the rat code, okay? And what the staff report quotes is from that February 28th, 2023 memorandum. It is not citing the manual, and it's certainly not citing the minutes, because the minutes from that March 20 meeting says, and I quote, the board approved, it's a typo, should say board approved, but anyway, the board approved the changes to petition validity codes and additional procedures described in the petition manual. That's what you guys approved. And so what's quoted in the staff report was from, again, I'll say it for the fourth time, was from this February 28th explanatory memorandum that said, these are the codes that we're changing and this is why. And all you did at that March 20 meeting was approve these codes. And there were no procedures approved except, again, as I just read, described in the petition manual. Well, those procedures are not described in the petition manual, either when you later did on October 2023, when you amended the petition manual, those procedures weren't described there. And as Mr. Brady has been fondly to say about stuff on your website, it is certainly not contained in your petition manual that's on your website now. So the fact that the statement that the board approved that you can ignore the validity of the address, and that's our point here. First, you have to have a legitimate address from which you can extrapolate the second address. There is no legitimate address here. The board did not approve that procedure.
But the board did say that this signature was valid, correct?
That this is a registered voter.
That this is a registered voter.
That he's registered at a different address, which is permissible.
Right. Yeah, right.
Sorry, I wasn't sure if that was a question. Bureau determined that he's registered in the jurisdiction at a different address than the address he wrote on the petition.
Looking at the codes, so there's a code for invalid address, and it says address is blank, missing house number or street name or PO box listed. It doesn't say invalid address, whereas for invalid city or township, it says there is no city or township by that name. For non-existent county, county does not exist. There's nothing that says the address doesn't exist. And what it says is that the signature is coded R if the person is registered at an address provided on the petition or registered at another address. And what Director Brader is saying is that this first voter whose signature we're looking at is registered at a different address.
And I think that's a good point, because if the standard is that you can legitimately live on that street, but if you omit your house number, you're out of luck. And if you legitimately live somewhere and you put the street number in, but you put the house number in, but you omit the street, you're out of luck. But if you're a signer that's making up an address and claiming on a legal document that they're the undersigned, qualified, and registered voter resident in the county, that you can just lie about where you live or
But
where
we
you're
don't
registered.
Have a code that says that if a person puts a number, an address on the petition, which is an invalid address, then we have to invalidate the signature. What our codes say is that if the person is registered at a different address, then that's fine. And it doesn't say if registered at a different address than the non-existent address provided.
And our contention is that this is not an address. If it's made up and it is not, it corresponds to any place where that resident could be, it's not an address. It's just a series of numbers and letters. And I do think that's captured by both the R, which requires another address, assuming that there's a first real address, and then the board has wide discretion under its miscellaneous code to adopt all what it thinks is the appropriate disposition.
The questions raised about what's on the website and the like, who pulled it up, and the wonders of modern technology. So IA invalid address says address is blank, comma, missing house number or street name, comma, or PO box listed. I don't believe Unicorn Drive exists as a drive in these communities. I mean, of course, silly example, but otherwise, like that's what this says. And this is consistent with what's written on the staff report, which cites to, I mean, I didn't make it up. I'm looking at page 4 of the staff report, cites, footnote 7. Perhaps that's too much in the weeds, but ultimately just to say, that's what the website says. People relied on it, not just us. I imagine you'll have a similar conversation with the other petitions because you're in the middle of a cycle right now. Maybe it makes sense to look at all these things come December.
And they didn't, but they did not rely on it to provide you with truthful information. None of these are places where someone could be. They're parcels that do not exist. We are not mixing up, this is completely consistent with the staff report that Director Brader issued only a few years ago, which is the same, the statutory language has not changed. So I think that it's important to understand the implications of this decision with saying you can write down a completely made up address and that's going to be fine. I think that's both inconsistent with the actual statute and your past practice. And I think it makes the future work of this board untenable in terms of getting valid and truthful information from signers.
And the analysis from a few years ago, of course, is before the 2023 activity. That's at play. So
Have these addresses actually been vetted as to whether they exist or not?
Certainly, we have GIS information for each one of these. So a good example is 62775. Can you find 62775? Yeah, that's it. 62775, the signer said that they live on Jones Street in Detroit. There is no Jones Street in Detroit. Now that can't be that someone transposed numbers or got their street name mixed up with the neighboring street. They made up the address. Why they did that, we don't know. But this is not an address that exists.
Is there any way to magnify the signature where they wrote the, thank you.
Mm-hmm.
Oh yeah, you kind of lose. I'm not sure if that says Joan, but anyway, okay.
But isn't
If it's helpful, they're registered at Joanne Street,
So
Joann.
Another example is 85406. And so on this one, the writer wrote that they live on Grand Rapids Street in Lowell. There's no Grand Rapids Street in Lowell.
well, but we just proved that it could be written, it could be missing a letter and it is actually a street. I mean, Grand Rapids, maybe not, but the one that you pointed out on Joan Street was
Joanne?
Joanne. It should have been Joanne Street, not Joan, which is a correct address.
And if that's a typo, that makes sense. If it's a matching address as well. But for ones like Grand Rapids Street, where that street does not exist, that's not.
That one would, I think we are gonna have to look at a couple of these, whether, regardless of where we're, like, this one is missing, this one clearly is probably missing a street name. I mean, that's what that looks like. I don't know where this individual is registered, but
And we're happy to go through those line by line. Shelby, do you want to go up to the top of this?
Well, so can I ask the Bureau, so the Bureau's position is it doesn't matter if they're registered.
So
Oh, and I'm so sorry.
That's okay.
85406 that we were just speaking to, our records indicate that that voter is registered at Grand River Street.
Mm.
I mean, what we do is we look them up in QVF at the address they provided. If they're registered there, then everything else is good, then of course they're fine. But then if they're not registered at the address provided, we then determine if they're registered or were registered at the appropriate, when they signed it anyway, at the address within the jurisdiction, at an address within the jurisdiction. We do not have a process of determining separately whether the initial address they provided, if it's not their address, is a valid address within the jurisdiction.
And I think that's similar, in a similar vein to duplicates, right? There's certain information that the board can't go foraging for with the resources it has available to it. But once, the question for the board is what the board does with this information once it is raised by challengers, and once they do bring that information to the board.
You feel we need to go through each one? I mean, I was hoping we could batch these, but I don't know if that's possible.
Would like to find a way to deal with these in a batch, because
Okay.
well, here's the point, is that if someone has vetted these and these are all in effect non-existent addresses.
But you already, but one of the mistakes was already the Joan.
That's what I'm doing, but I'm saying that, you know, we're gonna spend a lot of time tracking these down.
But how many are there? How many of these are there?
There's 12 in this batch.
12.
Okay.
But if it's the question is not whether it's a non-existent address. The question is whether they're registered at an address in the jurisdiction. And that is what Director Brader, that is what we have consistently held. We're not looking at what is on the sheet specifically, but whether they are a registered voter
At that,
in that
jurisdiction.
jurisdiction. And if that is the answer, then we don't have to figure out whether each of the addresses whether they may have missed a digit or
We can
whether
go
they
through these and we
said
can verify.
Joe
with
instead of
QVF.
Joanne. People are careless.
Right.
But if the Bureau has determined that they are registered voters, then that's it.
And that was part of the staff report already.
Already been done, correct?
Yeah, so I mean, if the board determines that, as long as they're registered in the jurisdiction, that the signature should be counted, then there's no need to go through them one by one, because staff has already determined that, although we can of course show you if you'd like to see. If the board determines that that is not the policy necessarily, that that the original address written needs to be a valid address, then we would need to go one by one and determine if each of these initially provided addresses is a valid address.
But I don't think we could say that because that's not what our codes say.
Right.
Our codes specifically say that if the person is registered at an address in the jurisdiction, then you count the signature. So let's not depart from what we have said we're going to do.
Respectfully, Vice Chair Garwitz, the code says if you're registered at another address. And so the idea that the initial address can be not a street address because there is no street, there is no place, that code still must be consistent with the plain language of the statute. And so I think the another is important there, because I think that we've already demonstrated that I don't think this board has said you can use an invalid address.
I think that's the threshold issue for
Yeah, I
the
don't
board
think we-
right now.
Can I
They
say
haven't-
something about that though? Because actually on page 40 of your 2025 petition manual, which is what my colleague was reading from, if a signer is registered to vote at a different address within the same city or township as written on the petition, the signature is valid. And what she says is, well, different address must be referring to an address in the world. But actually, if you look at the previous sentence, it talks about the city or township indicated. So obviously, when this board in 2025 voted for this language, that what they were saying is if there's an address that's different from what's written on the petition, but in the same jurisdiction where the person is validly registered, then we count that signature, and that has been the practice of the Bureau. And so again, that's something, you know, it's possible might warrant revisiting at some point out of cycle, but this is what the
Right.
petition manual specifically says.
Right.
I'm sorry, what was the exact quote?
I'm sorry, where did I get that quote?
What version of is that dated?
I am reading the July 2025 ballot proposal petition manual, page 40.
Okay, I read it as registered at for the R code.
Yeah, so I'm reading where it says very specifically, if a signer is registered to vote at a different address within the same city or township as written on the petition, the signature is valid. This is describing the NR code, and going the sentence immediately before that describing the NR code says, on the date of signing, the signer was not registered to vote anywhere in the city or township indicated. So it's referring to the address indicated on the form, and different address means different from what is indicated on the form. It's just the plain text of the provision that this board voted.
True, that's the NR code, but that's distinct from the R code, which I think the important thing for MOP is whether you are registered, not whether you are not.
Let's look at that. The
Yeah.
R code, registered at address provided on petition or registered at another address within city or township listed on the petition. So again, another is referring back in the same sentence to the address provided on the petition. And what my colleagues are trying to read into that is, well, it's not just the address that's provided on the petition, but it's the address that we can go and find on a GIS search. But that's not what this says. This says the address provided on the petition or another.
Yeah.
Have these 12 been verified that they are registered voters in these jurisdictions?
Yes.
You think? Gorgeous. You're awfully quiet down there.
I mean, I think that it is crazy that people can make up addresses to put on a petition. I mean, that makes absolutely zero sense. I'm reading, I'm following everything along here. I think for people to be able to put on here, for a made up address to not be considered invalid makes zero sense to me. Just not. I understand, I'm reading along with everything. I know, I know that we're looking at the exact language of this. But for an invalid address, or excuse me, for an address that literally just doesn't exist in the world to not be considered invalid, just doesn't pass any smell test.
That's not true,
It
because
is-
there's two that
The
were.
question is not whether the address on the petition is valid or invalid. The question is whether the voter is registered at an address in the jurisdiction. And that has been determined. So if somebody was careless, if I wrote my address as 166 instead of 1665, so what? When they look me up, they're going to find out that I'm addressed, I'm registered at 1665 my street, right? So.
But if you,
Take more time
know,
on this
yeah,
because we've got a lot to go over.
But one of these, Mr. Cortez was correct. The Joan.
yeah, understood, which is why I said, I think we gotta look at it. Like, we may, I agree. I'm not saying that all of these
No.
are incorrect. I would argue as well that Joan and Joanne, misspelling 100%. I think that comparing missing an N to having an address that literally just doesn't exist,
agree.
that's not the same thing. I would also say that, if you said 165 instead of 166, that's fine. But if you're missing your house numbers in general or your street name in general, then it's considered invalid. So, I mean,
Except we don't have a code that says that. And that's not what the manual says. So we are really bound to follow the rules that we have established. And they say that if the person is registered in the jurisdiction, that's what counts. We have the Bureau has advised us that the people on these 12 different petitions, these 12 different addresses, the people are registered in the jurisdictions. And so that's, so
If we want
count.
to change, I
They
agree
count.
with you, right? And if we want to change that rule, we can, but not retrospect. That's not fair to.
I think that's our point with what the Bureau has done in the past, because we're not asking you to change I understand having to be consistent with your codes. We think that this is, but first and foremost, you must be consistent with the statute that requires a street address. That's what a court will say is the application of strict compliance here. It has to be a street address. And if it doesn't exist, it's not a street address. And that's what Director Brader has held
I know.
in knocking out an entire petition for not providing a valid address in the heading. And that is irrespective of the timing of when your rules were adopted. That is based on the statutory language.
So if you got it wrong, to opposing counsel's point, the court will tell you that. They're going to file suit, or we'll file suit. I mean, you know how this plays out. This is not your first rodeo. And so in a certain respect, ultimately, you can only act consistent with the law. I believe that what you've done, your rules and standards are consistent with the law in all the ways we've discussed. But you set your own rules. You're bound to follow your own rules for this cycle. And if you got it wrong, which is what I think I hear, opposing counsel saying, and maybe you did. You got it wrong. I'm sure I'm going to read it about it in a brief, right? In court. And so it's the court's job, if you got it wrong, to correct your rule. You're not
I
on,
understand.
you're not on this as you're not here because you're lawyers. Some of you happen to be lawyers. I don't think all of you are lawyers, I think. And so that's beyond the scope of what you've been asked to do. It's beyond the scope of your authority or jurisdiction. Yeah. So, maybe they're right, maybe they're wrong. That's not your call. You've got rules. You got to follow your own rules.
I just think it's also important for this board, if there was a question in your mind, did we approve that? Did we not approve that? We've demonstrated that what that language was not in your minutes, not in your procedural, your code guide, and not in your what you ruled on back in 2023. So I think that if there was a question like, did we say that you can use a wholly invalid address on a petition sheet, then that's not changing, you're not changing the rules at this point.
What I'm trying to sort out is I remember that meeting. As a matter of fact, I remember some of the legislation because that happened to fall at a time that we were invited over by the House to testify. And we had a lot going on, and it was a lot with procedure manuals, and it was a lot with policies. And I remember very well that we went through the codes, and I remember some of those meetings with Vice Chair Gurwitz and with Director Brader. I remember a lot of conversations. What I don't remember is ever having a conversation about if somebody decided to invent an address, is that legitimate? And so what I'm trying to listen to you, and if it looks like I'm dreaming, I'm listening to you very carefully in that it sounds to me like you're deducing that portion from other minutes. I can't find reference to it anywhere, but I can't find reference to there's no reference to it in the meeting, in the minutes to the meeting. There is reference to the fact that we eliminated some codes, and we're very familiar with those codes. I'm not convinced that by eliminating the rat code that suddenly made it okay to create Disney addresses. So that's what I'm listening to here. So I'm looking to my fellow board members here for some insight.
I mean, I've said it a couple of times, I think, but what the director has said is consistent with both our manual and with our codes, which are appended to the manual, which say that if you're checking the validity of a signature, if the signer is registered at an address in the jurisdiction, then it's a valid signature, period. If the person, maybe they scribbled the address, maybe they were in a hurry, maybe they left something out, maybe they made something up, which is what Ms. Flower is contending. But if they did, our rules do not say that we compare the address compare the address on the sheet to another address and decide them. Actually, they specifically recognize that the determinative factor is whether the person is registered in the at an address in the jurisdiction. If they are, the signature is valid. We're not directed to look, nor can we look, whether in fact the address which somebody put on the petition, whether it's sloppy or otherwise invalid. That's not an inquiry that we are directed to make.
But you are required to canvass the signatures, and this encompasses the canvass that is your duty to make sure that you're complying strictly with the Michigan election law. If someone mistakenly writes down their birth date, they're out of luck. You have to provide the date. If someone writes down or omits, like I said before, their street number or their street address, they're out of luck. It doesn't matter if they could say, I signed it on that date, or no, I just forgot my address and I do live there. It's strict compliance is what's required here. And I understand that there may be some differing ways to read the codes, but what prevails here is the actual text of the statute. And there's plenty of examples of where failure to reach that strict compliance standard results in invalidating the signature. In fact, the statute says that's exactly what you have to do here. That's not the case with zip codes and other items.
And the examples that were just given in terms of date, and the like, guess where they are? They're in your manual on the website. Those are the rules that you've laid out, that my client, that other clients have followed. This was adopted by you, the manual that's on your website. This is July 31st, 2025, less than a year ago. We didn't come before you until August 22nd, 2025. Tell you what I was advising my client at the time was, here it is. We had been using the old version. No. They just updated it, July 31st, 2025. Talk to, the folks I've been working with. They'll have a copy of it. When they ask me a question, I say, all right, let's pull up the manual, right? We go back to it. Why? Because this board, not like basic decency, but also it makes sense. These are the rules that you set for yourself. And what the statute means, that's why we have courts. That's the division of labor in our society. That's the check and balance between the judiciary and others. The meaning of the statute will be teased out in a lawsuit. I'm sure we can have no doubt of that, right?
I'm sure you guys will help us with that. There's
Yeah,
problem
no
with
doubt.
that.
Yeah. So you're welcome in advance, one way or the other. But that's the role of the courts. It's not the role of this body. This
I
body has
understand.
rules. Thank you.
No, I understand and I appreciate your comments on it. I think we have to keep this, we have a lot to go here yet. We have to figure out what are we going to do with these 12? Do we want to go through them individually and do something with them? Do we want to take it as a block?
I think where the director has advised us that they have confirmed for these individuals that they are registered in the jurisdiction, I think we have to say those are valid addresses. That is what the manual says. That is what the appended codes, which are part of the manual, say. I don't see how we could say otherwise.
Yes.
As crazy as I think it is, I'm in agreement that you can't change the rules now. I also think that, I've always said this too, that I think there should be a very high bar for removing valid signatures on these sheets. So I'm willing to move on. And
We are moving on. This block is put aside.
Okay.
Thank you all for your, Ms. Flowers, even when we don't agree, I truly admire your structures and your arguments.
Appreciated. Thank you. Well, I admire your patience. Thank you.
Oh,
All right.
Before we move on, We have a request from the audience here. Can we take 10 minutes and just give folks a chance to, you'd like that too?
love it.
Gotcha.
No dispute.
Yeah.
Ms. Flowers, we found something we can really agree on. All right. We are back. We are on section C. And by the way, just a quick note, we're gonna pick the pace up here. We are running out of time, so before the Senate cancels our lease, we have things to do.
Chair, I was wondering if we could just do a little, do the exhibit that I just handed you first. It's damage. It's pretty easy to whip through.
Would you like to do those first?
Yeah, I was thinking we could
Let's
just whip
mark
through those. I know those are,
Is that it?
yeah. Those are line by line, but it's
Yeah.
a pretty fast. You guys have reviewed damage a lot this election season, so it should be pretty easy.
We can do that. Section M will be done first.
Yeah.
You want to start off?
That sounds good. So yesterday we filed a supplemental response regarding the our final review of the physical sheets and sort of pulled everything together for you so you could see across the three pleadings that we filed what everything looked like altogether. Because just the nature of going in a few different times to review the physical sheets, everything wasn't done by the July 10th deadline. So the first one, and some of these were invalid on other grounds, so we're just going over the highlighted ones. 38827. So that is already invalid.
Oh, I see.
Yeah, yep. So we just wanted to, yeah.
Maybe that.
Is it this?
Yeah. there's like a
Can you
little-
come up here and take a look here? Sorry, Jeff. Oh, Olivia. There we go. We're trying to see where this is the actual. This is 38827.
Right where, I think I know what you're seeing, but this is a no-go. There's like a little smudge right there, and I don't know if it just happened, but I think we can move beyond that one.
All right.
Okay, well, when you say that, you mean you would reject this?
You would
Reject the
reject.
challenge.
Yes.
Reject the challenge. Okay. On 38827.
Next one.
Okay, next one is sheet 57, no, they already got that one. 101265, line 5.
The other one,
There's a mix of, in this exhibit, we compiled everything that we challenged for you in one place. Some of them we're not addressing ones that have already been adjudicated. Trying to save time there.
This 1165. 17 letter.
Yes. And so this is, the issue here is the circulator, the signature crossing out portions of the circulator language right there.
And our
It's a combined damage MRE exhibit.
yeah.
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 Get it? Come on, Aaron. Because he says that because the signature covers up the word signature. On one letter in the word signature. Yeah, oh, come on, Eric. That's ridiculous.
It covers,
We don't have time for this.
All right, that one's out.
Oh, we reject
Okay.
challenge.
For 62725. This one is the all scribbled out on the signature language as well. There's words, there's words crossed out. I believe the standard that you held me to earlier this year was whether there were complete letters missing.
And our response here is that there's a distinction between this instance and other, there's some other pictures in the packet where somebody, I think, is correcting a date and they like scribble something out to scratch out a date and then they rewrite the date. And making a distinction here in that they aren't crossing anything off. This is just the signature. The signature is large. And that's the space for the signature. And there's nothing in the act. It's not like there's an act of crossing something off. There's the act of signing. And the signing,
Strict compliance requires if you can't see it, or if you can't, if it's crossed off, if it's not there.
we can see it.
Okay, we reject this one.
Okay.
That was 62725?
Yeah.
Okay. Okay, these last ones are all
These last nine.
new. Okay, so these are the ones we were just able to review yesterday.
Okay, we,
Sorry, 86539. These are the ones that were just made available yesterday. These ones, the petition is torn.
no, that one was done from.
oh, there you go.
Oh. Is it?
Yeah, that's the guy.
Sorry, did you say it's?
Yes.
It's done from.
The two that we wanted was, A6. That one is torn was for another one.
Oh, it's already invalid is what you're saying.
Oh, it's already,
Yeah, it's already valid.
okay, we don't
I was
need to
looking at
argue
the
about
stuff.
that if it's already invalid. Okay. Next one is 88702. So this one is where there is whiteout, crossing out the circulators, covering or obscuring words in the circulator certificate.
88702.
Yes.
Oh, right here.
I think the last time we considered this kind of thing, we said if you could tell what the word was. I mean, I know that we have agonized over these.
What you held me to in the Karoy case earlier this year was if a complete letter was missing.
Look at, this was just a piece of paper that's been over. That's pretty cool.
Yeah, I mean, right there you've got.
Probably not.
This is where
You got a
somebody
whole
had-
word, you got a whole word missing here. That. I,
You cannot read the entire township.
yeah.
See the mark.
And when we had. He had damage. Exact same.
Right, but didn't we say that if? you
Member
could say
Cordes,
the
you are
word-
correct. That was my case.
If you knew
so.
what the word was, I can't remember.
I would say that this compared to when there was a vote to qualify this.
What you're saying is you're gonna. Which rule? Where we go to.
Remember what, like, you give instruction.
I think we would probably toss that one, and that would also be one. Okay. They're all up to you ultimately.
And I think it's important to recognize too that this was one of the ones that hadn't been previously pulled. So I don't know if your team had had the opportunity to review it at the time of the staff report.
I would not say that that's damaged so as to affect the essential element, but we may disagree on that.
This would probably do. I would invalidate.
And I would validate too.
You know, if the argument is that that's where the
That was
clip
in
was,
the exact
Okay.
area. Yeah.
Okay.
that one. Next item.
All right,
This one's out.
almost done. 96177. This one has some sort of substance on the back of the sheet. I think it's probably helpful to review the physical sheet here.
Yeah, that one I would.
I just have a photocopy.
What's the rule?
What's the rule on
Can you read underneath the schmutz? I think.
I could make it out if I really tried hard, or if I scratched this off, and I'm not going to do that. No, that one I would go with the invalidating. Good at that?
Where you guys, what it, you can't read it?
No, I think you can read it.
I would contend it's the same issue, just a different color.
Did you want to knock it off?
No, I'm not.
Okay.
Wait, I'm sorry.
I would say that if you were out in the field and you had that, I think the issue here is you have a damage petition, you can't knock that off there. If someone wanted to read the back of that, knock that off. there.
If someone
You
did-
mean
But
you-
that's not your
You could brush off the schmutz. is what
board,
you're saying.
board
That's
member
what
Corda.
it's got there, you know, like.
Okay. so-
Likewise, you could pick off
so we are
whiteout, but
Rejecting this challenge, is that what you're saying?
That's where I would.
Okay.
may I have
How
a
about
moment
you?
to rebut
We're
that?
Rejecting this.
I'll make
one?
it quick.
Very quick.
With whiteout, it's not with damage. It's not a matter of whether it can be undone. If someone did it in pencil, scratched everything out and then erased it, that's not the standard. The standard is right now, is it damaged?
Sorry, letter miss.
No, we can, I think we said that we can read the words, so.
There is,
I think the
Okay.
manual says obscure. But you can read it.
but that's not the standard. The standard is strict compliance. And I think this is different from the ones you reviewed at the beginning of this packet. I think there are clearly letters missing, which is the standard that you articulated in April or May. Yeah, this was also part of this sheets that were just available yesterday.
Maybe the Bureau put the schmutz on there. No,
Okay, we don't need that. We don't need that in our life, please.
I shouldn't have,
Uh,
but
So no, this is
We're-
one that we just looked at yesterday. I think we did not determine it should be invalidated when we looked at it yesterday. I mean, it's partially obscured. I mean, again, this is one where we probably would say this is okay, but it's definitely one that we would pass to you for determination regardless. So.
And I think we determined that,
Yeah.
that we would reject a challenge
I
for
would
this one, right?
Yes.
Okay.
Okay.
Next one.
All right, I had just included 56650 for because we got to review that one yesterday. So 66173, line 9. This one. Oh, we can move through those ones. There was one issue with 85050.
Sorry, are we not
Right.
doing 6-1?
This one? 66173. We had provided those for reference. We had not previously provided you with these sheets in our prior, so this was from our yesterday filing. In our July 10th filing, we hadn't provided you with pictures of the sheets, so we were just doing that as a courtesy yesterday. I think we can move on from damage.
Done with damage?
Okay. If we would like to go back to C,
We're gonna go back to C.
okay.
Not an exhibit.
Good deal.
Which not a huge, I just want to make sure there's not.
So just for the record, you have invalidated one of the sheets.
That's right, double check. Thank you.
887. That's what.
That is a Jenny question.
Oh, and
Yeah. Okay.
forgive me, before we leave damage, at the end of section A, we had squared up to make sure we're all counting it the same way. By my count, well, yeah, just make sure we're all on the same page.
Okay, so in that last section, the damage section, the board rejected 1, 2, 3, 5 and accepted 1. So at this point, they have accepted 6 since this morning.
With 7 as an asterisk.
There's 1 deadlock and 1 hold in addition to those 6.
What's the whole?
The Janelle. The double scan.
The deadlock is, sorry, I can give 89162. And the one that's on hold is the one that's the possible scanning error. That's 108618.
And just to keep us moving here, the clock is continuing. The plan here is to have this wrapped by 4. We still have other business in front of the board. Okay.
Yes. Okay, our next section is C. I think this what we've provided here, the board has looked at a lot of Wickman challenges this election season. There's been additional litigation with Baslock that I'm sure the board is also familiar with. The staff report, the issue that raised a few issues, one of which was an evidentiary issue. They didn't know whether there was a city or township for the out-of-state circulator to provide. And we went through them, and there are 3 that do. Harris, for petition number 66. There's a Granger, here, let me organize this for you for one moment. North Carolina 66122. Granger, Indiana 80276. Granger, Indiana 83812. Granger, Indiana 84676. And Hiddenite, North Carolina 69616. I think it is important to note that on these petitions, They all had townships that they could provide. And additionally, for the Indiana petitions, they failed to identify their correct county of registration. They wrote Harris for their county of registration. That's not a real county. So, do you have anything more to add on
Well,
the Wickman challenges?
If I may.
Yeah, please do.
The staff report initially did not accept these challenges based on the Wickman. And just so we are clear here on what Wickman is, on the circulator certificate, it says, you know, city, township, or state at the bottom. And what Wickman says is you cannot merely add a postal address. You can't, it's got to be either a city or a township, period. Wickman did not distinguish between in-state and out-of-state circulator. So what Wickman's in the Bureau staff report, they said, hey, challengers, you didn't give us what city or township they should have put down. Because they, in all of these petitions, there's only two circulators we're talking about here, the Hiddenite, North Carolina, and the Granger, Indiana. Those are unincorporated places. Those are neither one of them are cities or townships. That's undisputed. So the idea here is that, well, they were supposed to have put in a city or township to be compliant with Wickman. And the staff's report said, well, you didn't tell us which city or township they should have put down. We've in fact done that. And in fact, there were two other challenges that we made to out-of-state circulators, one for Chantilly, Virginia, and one for Dead something or other, Dateland, Arizona. We did not put those challenges in this July 21 letter because pursuant to the staff report, we could not locate a city or a township in those two jurisdictions for which the out-of-state circulator could have put down. But so we took the staff report at its gospel and we put down, okay, this was the township that they should have put down, and they instead used their postal address, which both Wickman and Baslog say you cannot do. Same with like Okemos, same with Hazlitt, you know, in jurisdictions within the state of Michigan. So, and I understand that there may be some sort of implied position by the staff. They didn't come out and say that somehow Wickman doesn't apply to out-of-state circulators. That's false. The Wickman case itself did not apply to out-of-state circulators. However, it didn't rest on whether the circulator in that case was Michigan or out-of-state Michigan. It rests on the very simple proposition that you have to put down a city or a township, period. And if you don't put a city or a township and you put an incorporated place like the petitions that Ms. Flower just talked about, then in fact, Wickman says the circulator certificate is invalid and therefore the signature is valid. And I'm happy to take any questions, or I don't know if we're going to Mr. Brady, but that's Wickman. And these clearly, and this invalidates only 3 signatures, even though we've got like 5 in the box there, because some of these were invalidated for other reasons. So this category is 3 signatures.
Mr. Brady, go ahead.
I think each signature is worth like 561. Yeah, but I digress. So once again, I think we find this is a legal question that the courts, I'm sure, will be hearing, you know, one way or the other, and whatever happens after the board weighs in. Wickman did not consider out-of-state circulators, full stop. And the staff report noted that for that reason. There have been other instances in the past where it's, you know, you could extrapolate, as opposing counsel does, what the court might say. They didn't say it. They did not reach out-of-state circulators. And this may also be one that, you know, will help clarify one way or the other through the courts, who get to weigh in and offer, but that's their role, not the role of this board.
I think
Well, as long as we're gonna, you know, as long as it's gonna go to court, we'll give them some sound bites too. This happens to be one that I'm really near and dear to because I actually went through every one of these and I looked it up to see if there was in fact a city or a township or anything else. And in both cases with North Carolina and Indiana, there was. And not only that, but you could identify pretty quickly where these folks came from. My take on those particular petitions that we're talking about right now is that the way they filled them out was simply sloppy work. Somebody just didn't care. And that's unfortunate. And I get really passionate about that because the out-of-state circulator issue has been kind of near and dear to us over the last couple of cycles. So I understand where you're coming from with those.
If I could just jump in, this signature petition sheet has one spot that designates in between if you're in state and out of state. It's the box. Everything else applies irrespective of what state you're in. The legislature said, provide a city or township. It didn't say provide a city or township if you live in Michigan and you have cities and townships. The petition sheet is meant to be used by anyone that comes into the state and wants to circulate it. And if you're from out of state, you have to check the box. I think that's, there's no differentiation in either the statute or the petition form for the city or township designation for an out-of-state circulator.
I'm sorry.
Well, yeah, so I mean, the Attorney General's office is gonna have to give you advice on how the case applies. Apologies to my friends down there. But as far as the Bureau, I mean, we don't think that we have clear guidance from the court as to if or how we should transport the Michigan-specific delineations between cities and townships and unincorporated places to other states' arrangements of municipalities, local jurisdictions, and voting jurisdictions. I am sure there is a sensible way it could be done. I just don't think that the Bureau is positioned based on the guidance we have from the courts and our limited knowledge of state statutes and constitutions and everything else to make that kind of recommendation. So based on that, we don't think we have a way to apply this to out-of-state circulators as far
By
as
the
the
way,
Bureau's
my
record.
comment about sloppy was not directed at the Bureau. You understood that, right?
Yes, thank you.
Directed at the circulators who filled these out.
But if I may respond, the Baslot case that we've also cited in our July 21 letter said that you cannot use a postal address. It's got to be a city or township. Again, while I agree that neither Baslot which is also a Court of Appeals decision, and the published Wickman case did not specifically address out-of-state circulators, they didn't have to. It had nothing to do with whether the circulator was in state or out of state. That's not the issue. We might as well say, well, because they didn't collect on a Wednesday, so everything collected on a Thursday is okay. That's a red herring. The fact is, they said you have to put a city or township in that circulator certificate. You cannot use your postal address. You cannot use an unincorporated place, which is what the circulators in these two situations did. That's the point.
So do we comments?
Do we get some Attorney General advice on this one?
Do you want Attorney General advice
Yes.
on this?
I was inviting it.
With respect to the Wickman case, we are absolutely aware of it. Wickman did determine that a city or township was required. However, respectfully to council's arguments, it's not that they did not distinguish between in-state or out-of-state. Out-of-state was simply not addressed in that case. It wasn't part of it because the issue was about the unincorporated village of Vulcan, which was in the state of Michigan. It is, I think we can only say it's unclear how the Court of Appeals or any court would review out-of-state cases when out-of-state law or other states' laws on what constitutes a city or township may be different than ours.
If it's unclear whether Wickman would require the rejection of these signatures, then I would not reject them. I'm listening to Mr. Cordes, who says that it's a high bar to reject signatures. I would agree on that.
Yeah.
So we're using the term reject in a number of different ways, but I would reject these challenges.
Yes, I would as well.
Okay,
Next section.
We are not done with them, however, because these Indiana signers have also made a false statement on the county line. They put Harris Township, that is not, or Harris County as their county of registration. That is not a county in Indiana. So there's two challenges there. I understand your ruling on Wickman. I respect that interpretation. False statement on a circulator certificate is, you're required by state law to toss those sheets out. So to the extent that you're also looking, I understand that that wouldn't apply to the North Carolina sheet that you just ruled on, but to the extent those Indiana sheets remain, we would ask that you eliminate those sheets based on the false statement of not providing the correct county for the circulator.
Comments?
I'm looking at this. I'm looking at this admirable research referring to the North Carolina Constitution of 1868. I'm not sure
There are
what
neighbors.
the applicability of it is. I mean, I think we're talking about something that's very close and about rejecting signatures of Michigan voters based upon some assertions regarding, I guess, the organization of cities, townships, and jurisdictions in other states.
Vice Chair Gerwitz, no, so that's the separate issue. This is just,
So you're saying that there are false statements.
I mean, if someone in Michigan did it, whether it's in Michigan or whether it's out of Michigan, if a circulator in Michigan did it, we would invalidate it.
Right, but how do we know that they're, I'm looking to see what evidence we have of the false statements. I just don't.
Can you point me to the exact?
yeah.
Paper.
So on page 11, the circulator wrote Harris for his county of registration. So the circulator may omit their county, but they may not provide a false county. They're located in St. Joseph's County, Indiana. So that's page 11. For the false statements, it is 1, 2, it's 3, and it's all the same circulator.
One's already out.
Yeah, one's already out.
Yeah.
Yeah, so it's 2.
Two.
We're talking about 2. Yeah.
As my colleague says, a canvasser can, or a person collecting signatures, a circulator can leave out the county. I believe Harris is a township in Granger, Indiana. And so what they were doing there was not putting a false county, but putting their township in the wrong place.
It's on the county of registration line. That would be inferring.
Understood, but like what else? I mean, they put Granger, Indiana, and they put Harris. Obviously, if Harris, the only valid inference one can draw is that they're writing their township. And they might have put it on the wrong line and omitted their county, but my colleague acknowledges that's acceptable.
Omitting your county is, but
Their township in place for the county should.
but that's not the way the petition sheets work. You cannot put your city or township in your printed name in your city or township and have it not, it's also not the same as a signature line. There's a higher standard for signature circulators because of the burdens because of the affidavits that they have to sign, because of the assertions that they're making about the validity of the circulator, of the signatures on the sheet. And you cannot provide a county of registration that is not your county in the county of registration line. That language is plain. The remedy is plain in 482E. The legislature has told you what you do in this circumstance. If you provide false information, that is not their county. We know what their county is. It's St. Joseph's. That is false information, and you're obliged to eliminate those 2 signature sheets.
I think the question is, were they putting their county? falsely. Right. Or
Right.
were they putting their township correctly but on the wrong?
But in the wrong.
But
Yeah.
strict compliance is not a question of intent.
Falsity
But-
is,
Falsity is-
falsity is is lying about something rather than putting something in the wrong space. And I think that recognition of that distinction is important. False statements can be criminal, or at least misdemeanors. And I think there's no reason to believe that these people were intending to falsely state the information. They just didn't put it in the right space. But they put,
And Harris is the township, which is otherwise their
Yeah.
effort to comply inadvertently with Wickman.
so we're talking here about the Granger, Indiana, the three.
That's my
So
understanding. Yeah.
I would reject those.
You are rejecting the
Yeah.
challenges?
I would reject the challenge to those, which I do not see as false statements.
But the
have-
statute doesn't say knowingly false. It says false statements.
I reject this.
Mr. Cordes? Rejected. All right. Are we in section D?
All right, moving on.
I would, again, remind you, please keep, comments
Yep.
need to be kept brief because we just burned 30 minutes.
Yes. Okay, invalid signatures. I think this is one where we can probably whip through these pretty quickly if the Bureau has the signatures available. Do you want me to skip to another section while you pull those? Would that be helpful?
D as in dog?
6
Is that right? D as in dog?
Yeah. or E? Oh,
Date of
D,
registration.
sorry, my apologies.
You don't
I
have to go
skipped.
for it. I.
Thank you.
Come up in queue.
The, not
They're placed
registered.
straight, you know.
Not registered. Do we have sheets for these? Yeah, okay. And they're in, we've pulled the individual lines. 68895, row 7, for city or township provided Dexter. Shelby can help me with that.
It might be 8.
D doesn't seem to have anything to do with this case. this
It's Exhibit
matter.
H.
What?
Okay.
Section
Exhibit
D
H.
corresponds to Exhibit H.
And dog. You've got the right one there. It's got Vance Patrick's letter. It's
Right.
got the next one.
Go to H.
Yeah.
Is everybody there? Okay.
Got H.
Exhibit, or so for Exhibit H, our first one, page number 68. Sorry.
I have turned it off, but it is unresponsive. Sorry.
No, no worries. 68895, this signer wrote Dexter. Their mailing city is Whitmore Lake and their legal jurisdiction is Webster Township. We contend that this signer was not registered when they signed the petition.
We agreed with the challenger on this, right?
Yeah.
Yeah.
Okay, then we don't.
You mean with this individual one or with all 3? Because we have responses to the others. Yeah.
Right.
Are you?
We're relying on I mean, this is the staff is best positioned to review the qualified voter file. This is a question of date of registration, so. With the staff's, assessment.
So that was it. So that's.
All right. Next, we were not able to identify a voter named Etiennette Hebert in the documents that were available to us.
But we were. So, in our response, our July 14th response, I'm looking at page 11. We found a distinct name match in East Lansing, and the name is Etienne. Hebert, maybe instead of the diminutive Etiennette Hebert, at the same address. And we note that nicknames are allowed in the printed name section as long as the signature agrees with the one on file in the QVF, which staff have determined was the case, consistent with their standard process.
We reject this challenge.
Yes, there is a Etiennette. The signature says Etiennette, and the first name on the registration is Etienne Hebert in Lansing. Well, East Lansing. East Lansing.
And the signature matches?
We're okay.
Yeah.
Yeah.
Yeah, rejecting that challenge.
Okay.
Yeah, oh yeah.
Okay, we're rejecting.
William Ford,
William Ford, we contend that he was not registered to vote in Clinton Township on the day that he signed.
Okay, so we agree with the challenge on this. The voter, it appears they moved into that jurisdiction or registered in that jurisdiction after signing the petition.
challenge,
Okay.
challenge accepted.
That takes it down one more.
Okay.
That's the end of the not registereds. We can do a.
What the, yeah, the count. Yeah, thank you.
Yes, we accepted 2 more. The board accepted 2 more. So 8 accepted total. So the new total is 649.
All right, Exhibit I. Invalid signatures. This is one where Director Brader, would you like to go through this now, or would you like to maybe queue these up and we can do something else in the interim?
Were you pulling cubic records for this?
Could I offer a response?
I think we can do them. Go ahead, sorry.
Yeah, I mean, I have more of a categorical response to these. This is, and just to confirm, this is section E as an elephant.
Yes.
And, yeah, so the standard that you've all laid out is the comparison of signatures against the qualified voter file. And, the exhibits that were shared with you and shared with me and that we looked at are comparing the signature to other things, that are not the qualified voter file. The folks who are in the best position to compare it to the qualified voter file have done it twice, at least. That's the staff at the Bureau of Elections. They did it once in normal course. They did it again once it was challenged. As has already happened today, they can pull those up and you can look at them. We can't. But the comparisons that are offered by opposing counsel are simply not relevant. They point to other sheets. The sheets they say, and maybe this is true, I don't really have a reason to kind of doubt that, but they don't, show the, this is how somebody they say signed Mike Cox for governor. Why do I care how they signed the Mike Cox for governor? It's not relevant. It's not your standard, and it's absolutely no bearing. Are we, how did they sign their receipt at the bar? Not relevant. Just not relevant.
Well, I will
There's
say,
a
Mr.
standard. The only standard is compare against the qualified voter file.
And I think we should look at the QVF on these ones, but
Yeah,
I
please.
will say that we have had extensive conversations about how someone could bring a challenge over the last year. And it was in comparison to other things that they signed. Like we have talked extensively about if somebody wanted to bring a challenge on a signature because they don't have access, one of the reasons for doing so would be by looking at other, past signatures on past documents.
And so to that point, I would say, if somehow there's a threshold question as to whether they've met the burden to make you spend time and look at the signatures, go ahead. But in the interest of time, I don't know if we need to see these at all. They're offering that as a reason why you should even give it another look. And I think you should cut right to the chase. Look at the signature on file.
If these are all valid signature issues, let's not do the dialogue. Let's just go
Yeah.
and look.
That's
up.
why I asked if you wanted
Yeah.
to skip to something else and
I mean,
pull up the QVF.
Let's get these resolved
Yeah.
So.
Yeah, so just for awareness for the board, I think there were 5 or 6 here, something like that.
6.
6. We did agree with the challengers on Bradford. We think we compared that signature to a different Tracy Bradford, and it matched with a different one, but not the one that was on the petition sheet, I think.
Forgive me, is that 97046?
I believe.
Yep.
Is that right? And they're in a different jurisdiction. Okay, so this voter, yeah, so I don't know that's necessarily an invalid signature, but they were in the wrong jurisdiction, Inkster versus Detroit. The rest of them, though, we did look up and we stick by our original determination that the signatures match, but I think, Jenny, do you have them pulled up yet? No, we'll have to pull them later. Okay, why don't we start there?
Are you able to tell us which one you're on currently?
Just did, Fred Bartholomew, that was it.
And which one are you on now?
We're just waiting to see
Okay.
who they're. Willie Cannon.
Perfect.
Is that 70805?
Uh,
So the standard we use is doesn't sufficiently agree, so like if people like, yeah, they might sign their full last name. And the first letter, if it- Got sodden, but no. What's the date of? This week's. Really? He signed it with his last name on the PDO, but the signature matches the Ocean statement. For the first. So they're gonna accept it. Even though this, signature is first of March. Okay, that's this one.
The Saudi one, we would also argue appears crossed off. It's unclear whether the signer intended to sign if if it matches. Okay.
Yeah.
I don't know why.
The cap of the J, just extend it out, yeah.
We are rejecting,
They're rejecting that.
Rejecting the.
this one, do you want to see this one? Reject 3537.
3537.
We reject 3254.
And I think the last one is Colleen Green, which I think Alessa's pulling up.
Reject 87607. Yeah. I think that's it.
I don't have that. 207 or 805. 972.
Yeah, so.
Would you mind running through
Yeah,
all of
the
those?
board determined, the BOE agrees with the challenge on this one as well. Tracy Bradford we all agree that the challenge should be accepted and that signature should be rejected.
Forgive me, is that
97046.
Thank you.
Essentially, we compared it to the wrong voter's signature and wrongly determined that it matched. The rest, John Wilkie, Colleen Green, James Sadi, Willie Cannon, and Fred Bartholomew. The board agrees with the Bureau that all those signatures match. So the challenges are rejected and the signatures stand.
Okay. Are we ready to move on? All right. So the next portion is circulators that failed to include Michigan in their circulator. There's 3 in this category. Michigan is a required, like including your state is a required element. Again, it gets to the issue that we're having with where do each of these circulators live. There is a city of Detroit in, there's at least 3 cities of Detroit. There's also various municipalities if the board is going to accept unincorporated places and towns, townships, other municipal forms. You must include the state. It's imperative in order to tell where the whether the signer has or has not checked the out-of-state circulator box properly. And these 3 that we've identified, I think the screenshots of the circulator boxes are in the section F of the challenge for you to review.
And our response, or whether we have a response. As noted on page 7 and 8 of the document that the handout passed out today, the staff report, I'll direct you to the staff report, page 8, which says that these 3 challenges were directed because, quote, omission of the state or both the state and the zip code does not violate the requirements of MCL 168.544C. A Michigan-based circulator's failure to indicate the state of Michigan on the circulator certificate does not affect the validity of the signature because when considered in the context of the inclusion of a city and sometimes also a county, as is the case for 2 of these, that is within the state of Michigan and an unchecked out-of-state circulator box, all of that combined, it is clear that the circulator is located in Michigan. And the staff additionally noted that all of the challenge circulators were Michigan-based. They then cite to staff report on Philip Tanis from May 14th of 2026. There have been other references to things that happened in April of this year and things that happened in May of this year. Both of those are very, very recent precedent of this board. Just ask that you treat them in a consistent manner.
My response is that 504C2, it's important that my colleague cites, it's important to actually read the language of it. The failure of a circulator or an elector who signs a petition to print his or her name, print his or her location prescribed by the Secretary of State, or to enter a zip code or his or her correct zip code does not affect the validity of the signature. There's no mention of the state there. That is a necessary element. I think it's also, insofar as we're talking about following your manual and making sure that you're not changing the rules mid game. Your manual says an address that's missing an element that is incomplete. An incomplete circulator address is expressly identified by the Bureau as a defect which renders the entire sheet invalid. The state is an essential part of an address or a circulator's address, and an omission of that part of that address renders the whole entire sheet invalid.
Director Brader, can you address your perspective on that?
Yeah, well, we have encountered this scenario before, as noted in the Tanis example. The zip code, I think, is pretty clearly, in statute, is not a reason to disqualify. But with the state in Tanis, we did determine that that should not be a reason for rejection when it is clearly somebody from Michigan. And that's the board, I think the board did accept that previously.
If I may quote, if I may quote your petition manual, it says the failure to include the circulator complete address, and in parentheses, it says street or rural route number, PO box is invalid, city or township and state. It specifically includes state in that list of required elements within what we're talking about here. And that's from page 41 of your manual. Notice that I didn't say zip code, okay? Zip code, if accepted out by statute, which is what the staff report relied on, and said, well, not everything there is required because a zip code's not required. But for you non-attorneys, there's this maxim of law, like expressio, I never pronounce it right, expressio unius, whatever. It basically means the reference to something specific excludes other things. The statute accepts out zip codes, but it doesn't accept out state, okay? Your manual clearly says that defines a complete residential address as including a state. So, I mean, this board doesn't have any discretion to ignore that. And also, if you look at the other carve-outs also within your petition manual, you do exclude zip code. If they didn't have the zip code, we wouldn't be here, but they excluded state. So your petition manual in two places has one for the list of exclusions, which state is not in. And then in the challenge code page that I read on page 41, and it's up on our screen there, it says complete residence includes a state.
And so, love to respond. He took the words right out of my mouth. I was actually going to mention expressio unius, because my colleague and I were talking about this just the other day, and on this very same section. So to direct you to 544C2, and if you wanted to follow along, so at least I knew, it was read once. I'm just kidding. My response on July 14th, dated July 14th, page 25, it's raised there in the context of Wickman. I'm not relitigating Wickman here, but the section cited, 544C2, the last sentence says, if an elector does not include his or her signature, his or her street address or rural route, or the date of signing on the petition as required under subsection 1, the elector's signature is invalid and must not be counted by a filing official. It's very specific as to when it is invalid. I'll just say it one more time. I'm not doing it, just one more time. If elector does not include his or her signature, not in play here, his or her street address or rural route, not in play here, or the date of signing on the petition as required under subsection 1. That analysis deals with the circulator section, expressio unius. When you say these 3 things, if they're not there, you have to invalidate. It doesn't say anything about if you miss something else, does it? It doesn't. That's exactly, thank you, counsel. Expressio unius.
But respectfully, that is, it's important to look at the text of that provision, because the provision that you just quoted only addresses electors, and section sub 2 addresses circulators and electors separately. They are distinct terms under section 2. The sentence you just read was just the elector sentence.
I think that's actually very relevant. So that there is nothing in section 2 that would require the invalidation of a sheet or circulator signatures here. And I'll just say the Court of Appeals in the Protecting Michigan Taxpayers case in 2018 actually specifically addressed what happens with circulator signatures, a case that was distinguished but not overruled in Whittington, and said, and I'm just quoting from the Court of Appeals here, this is dealing with, it says, note in subsection 5 in 544C, there are 2 circumstances identified for when a circulator, by omitting certain information, will invalidate the entire sheet. And the Court of Appeals said the statute governing the rules that circulators must follow create specific penalties for negligent and intentional malfeasance. Those penalties do not encompass the negation of elector signatures, except in 2 distinct circumstances: when a circulator collects signatures after signing the date of the petition, or when a circulator fails to sign the sheet entirely, and then goes on to talk about expressio unius for a while. So I think the fairest thing to say here is this is a matter on which the statute is silent. It says certain things are definitely going to negate a sheet. It says certain things are not going to negate a sheet. And this is not one of those things that definitely negates a sheet according to the statute, or that definitely doesn't according to the statute. Under the democracy principle articulated by the Michigan Supreme Court, the tie goes to the voter. We shouldn't invalidate an entire sheet of signatures because of some error by a circulator.
But protecting Michigan taxpayers, it's important to talk about that case. Yes,
Well,
I will make
we've
it
got-
brief. If protecting Michigan taxpayers involved the circulators making up addresses, and the state passed 582E in response. So,
Olivia, play
yes.
along with me. Here.
okay,
We've beat this horse to death.
Yeah.
Just now, let us have our time now. And so,
I would just say we kept in all, based off the manual, we kept in all the fake addresses. I would agree that if you just read if you're just reading our manual, I mean, they are missing something that we say that they need to have in the manual.
what are you saying? Where are you standing? How many of those have you got?
it's 3.
Yeah, 3. Are we accepting the challenge on those 3 as missing the
What
information?
are your guys' thoughts? I mean, took a very literal reading of the manual on the fake addresses ones.
I don't see in our manual that it says that the failure to include state is a violation. I'm persuaded by Professor Bagenstas' articulation of the expressio unius discussion in the case which he cited, and by Director Brader's assessment of these challenges, that we should reject the challenges.
Your vote is to reject the challenge,
Yes.
Ms. Cummings?
I mean, it says in circulators, failure to include the circulator name, complete residential address, street and or rural number, PO box invalid, city or township, and state.
It's in the manual.
It's in the manual.
And this is being super picky, but that's obviously what we're doing here. In the codes, what it says depends on, oh no, I've lost the
And
code.
Vice
Oh,
Chair, like
here.
we have it right
Failure
here.
to include the circulator name, complete residential address, city or township and state. So city is enough without the township and state.
I don't think,
So you can have the city or township. Is that the correct?
Yeah, it's right up on the screen.
Right.
State is a distinct requirement under
Depends on
544
where you
C1.
put the commas.
Someone just didn't like Oxford commas, apparently.
I don't know who Philip Tanis is,
Some-
but again, you addressed this issue 2 months ago.
Yeah, I'm gonna agree with, board member Curtis.
And you are going to agree with him and you are going to state what you
I would
want.
accept the challenge.
And you, I'm going to accept the challenge on this one too. So I think you can, what would you like?
Okay.
What would you like?
Well, it's three,
It doesn't matter.
it's 3-1, right? So I don't count. So
Well, you know, you always count. All right, next item.
That knocks out 3 more signatures, right? Okay.
Which is it? 6:45?
Olivia, where would you like us to go next?
I think we're at the end here.
We are.
I think we are at in terms of line by line, we are at the miscellaneous, which is Exhibit L.
Exhibit from today, the packet you gave us.
That was M, the damage. Yeah. L is,
Oh, I got
It was section H of the document?
okay. Is it helpful to have a count or are we just moving on?
The only ones that I see that you still haven't discussed, so we're at 6:48 now, we're down to 6:48. I think there's only 4 more that
Mhm.
are being challenged at this point, that are for miscellaneous reasons under the Michigan election law. Is that? Got Orozco, sheet 102-423. I've got sheet 35277, sheet 52577, and sheet 3131406 is the last 4 to consider. Is that
Correct,
right?
but-
Jenny, what's your total? Come down.
We're at 6:48. There's 4 more to consider.
Yeah, one's, I actually, I have 12,
Yeah.
one with an asterisk and one with a hold.
Jenny, why don't you just read off where we are in terms of number?
Okay, I have that we've accepted 9. We're deadlocked on 1 and we're hold on 1. So we started the day at 6:57 and we're at 6:48 with those 2 left to consider.
Have you added the 3 circulator ones that they just,
I did.
okay, that, I think something went awry then.
Yeah, I'm at 12.
I'm at 12 as well.
Okay.
Which with a total of 6:45.
Did you add this?
Is that right?
6:45.
I have us at 6:45 as well.
Yeah.
I also have 6:45.
Yeah.
All right, 6:45,
Yeah.
because we weren't counting those last 3
Yeah.
circular, sure. Okay.
Okay,
So we have 4?
yes.
yes.
I think it's important
Yeah,
for the
I
record
think
to be
they all
clear.
matter.
Agreed.
So how do we proceed?
Okay.
Better wrap this up quickly.
For,
Screening.
yeah, sorry. Shelby, could you turn on the screen for Exhibit L, the miscellaneous?
Right.
Uh, Okay. For this one, we did not believe it was sufficiently legible to identify the voter, and then they appear to have included street as their city or township.
It's 102423.
Mhm.
So we did think this was illegible. We know that, we can understand why the staff report thought it was illegible. I directed to page 8 of the handout that I passed out this morning, the bottom of page 8. It goes on to page 9 as well. It begins by quoting, or the staff report quoting, challenge that a line is illegible if the Bureau is unable to read enough information by the signer to identify the signer. Noted that that mirrors the board's approved standards and procedures as they're laid out in the ballot proposal petition manual. One other point, the staff were, then able to check it. So they didn't, not only had to be able to read it, but then they had to find enough information and then check and see, did the signature line up in the QBF? And so according to that process, they had enough information, they were able to do it. We also had enough information. I look at, directed to page 9 of my response, a little, map here. While perhaps not model handwriting, the script is clear enough. The street address of 6325 is GRANDMT, clearly shorthand for 6325 Grandmont, MT being, an abbreviation for Mount, located in the city of, and then it's spelled DTROT, which is obviously Detroit, and it's in the zip code of 48228. And I included a Google map of 6325 Grandmont, located on the west side of Detroit, in the zip code 48228. According to White Pages, the signer lives there. More importantly, the QVF indicates that that individual is registered at that address. And I include on page 10 of my response, the information that we received from the VAN, the Voter Access Network, which details a voter's registration. So I think I can understand why there was a question about it, but in looking at that and zooming in, and then, looking around, we were able to see that this individual, see the address, see that the individual lives there, confirm that person is registered there, which, isn't a rebuttal. It's frankly confirming what your staff already did, because they're professionals and they already know how to do that.
We're gonna talk about this, so we're gonna want this, but then I'm gonna change the rules here, not your rule, my rules. We really truly are running out of time, and I have to remind you, we have public comment, and legally we have to do that. So here's the deal. We're gonna spin it up. So instead of letting you folks explain what's wrong with it, we're gonna go through. Olivia, you're gonna lead us through like a list. Here's what we're looking at.
Okay.
You're not gonna talk about it. What you're gonna do is show it to us. We're gonna ask you questions, and then we can make decisions on these. Fair deal?
Works for us.
All right.
I just have one question. Did you find someone registered there and did the signature match?
Yes, yes.
Right.
Okay, are we gonna,
Yeah.
yeah, I think I would reject the challenge. I think that's
You would accept it?
illegible. I would reject the challenge.
Reject the challenge.
Right.
I would reject the challenge.
What is?
If you found someone there and the signature match, then yes, I reject.
Next item.
35277, line 2.
Did you find this? Director Brader, did you find?
Yes, sure definitely matches. Trying to identify the alleged spelling error. We found it.
Quite a
matches.
quite a distinctive signature.
So, I mean, we found it in the signature matches. Yeah.
Reject the challenge at 35277.
Yes.
Yep.
Yep. Next.
52577. The issue here is the city or township is not included on the line. And a signer can't combine two signature lines to create a single valid line.
don't think we rejected based on folks doing that, like completing their address in the line below. So we would reject this challenge as well.
There is a signer that is crossed off on the line below.
Page 10 of my handout today zooms out and shows you the full context, and that signer then signed one or two rows below. So if you look at that, I think that's very informative. What was included in the exhibit is zoomed in on the one signature that's actually an issue, but given the context, it's not on, well, maybe,
Yep.
you can see, yeah,
Yeah.
forgive me, thank you.
Well,
I say that the city Mount Pleasant like literally straddles the same black line. It does cross over. They're both on the black line. That says 1526 Canterbury Trail, Mount Pleasant, Michigan zip code.
Reject the challenge.
I reject the challenge.
Rejecting the challenge. Challenge is rejected.
That's to 52577.
That's 52577.
All right, last one, 31406.
Looking at the 2026 on that one.
That's right, 2026. And
I
you gotta,
I
Oh.
believe you had to add additional lines in your challenge to make it appear.
to be clear, I acknowledge it, it was very clear. There's nothing, kind of untoward here. It was simply the darker line superimposed to facilitate seeing the fainter curves. The curves are there. If you zoom in, as I did on my computer, I could see them plain as day. And you can see the curve for each of those. And so I just direct you all to page 11 of my handout today. You can disregard my art, because it's not really my art.
We would ask you to look at page 11 because he had to add in stuff to make the numbers. So we would ask you to look at his page 11, please.
Can't unsee it.
From staff's perspective, I mean, it is light. This is one where we wouldn't have a strong recommendation on either way.
And we're happy to return to our earlier dates that were rejected, if that.
Yeah, I already know.
I was thinking the same thing, actually. Because they won some dates that I was like, wait till they get to the end. I'm gonna apply that standard.
Right.
Yeah.
You like that little curve, that little
Yeah.
sort of faint six, right? So.
It's line 2.
Oh, I think that's okay.
I can read that.
Yeah.
I would reject it.
Rather, yeah. Easier to read.
Scanner issue.
Reject that challenge.
Yes.
That one's rejected. Next one.
That's
Sorry about that. No, that one, it actually looks really good on the real McGoy.
31406.
No.
Checked.
Um,
7.
Circle back up.
Are you finished with the?
not with the line by line, yes. We had a few additional pieces. We will make it quick. One large concern was the duplicate signature rate. 148, we had 148 duplicates that we found in the sample. Obviously, that was reduced by the number that the staff rejected. That corresponded to 204 signatures in the universe. So people were signing this a lot of times. One person signed it 8 times that we found in the sample. 2 circulators signed it 5 times, including twice on their petitions on the same day. We would, to the extent that the sample is representative of the universe, we think that all duplicates should not be treated as one-to-one. They should be treated in accordance with the weight that you find the duplicate for. So is it going to be the same? Is the likelihood of you running into multiples the same in every sample you draw? Yes. But to the extent that each signature is representative of the multiple signatures in the universe, that if you treat them according to their multiple value, that would be determinative today. It'd be the difference of 31,474 signatures. So I think it's important that to understand that you're treating each duplicate to eliminate 561 signatures. So you're not eliminating the right number of signatures in the universe. You're just eliminating what it would be if you found one-to-one.
Yeah, might I respond to that? That's just so we understand. So I think that just fails to appreciate the math of the way that a sample works, is comparing a numerator from the entire universe to the denominator of the sample. So it's overweighting the numerator by about 561 times. So the whole point of the sample is you take the numerator from the 1,000-person sample, the 1,000-signature sample, and the denominator is 1,000, and then you extrapolate that out to the rest of the sample. What they're doing is taking the numerator from outside the sample. We found 200, they say, duplicates outside of sample, and we're taking that over 1,000 and then extrapolating that back out to the sample. Let me just give you a simple example of why that doesn't. Imagine you have 100 signature universe, and you have one person who is signed 10 times in that 100 signature universe. So 10% of the signatures in the universe are duplicates, and they should be rejected. In a sample of 10, you find one signature that is duplicated 9 times outside of the sample. If you apply the established rule that this board has applied, looking only inside the sample and then extrapolating out, what you find is, well, 1 out of the 10 signatures in the sample is a duplicate. So we extrapolate out 10% duplicates. We treat the universe as having 10 duplicate signatures. That's correct. That's the correct number. Under their analysis, because the sample contains one signature that's duplicated 9 times outside the sample, we would take 9 signatures, make that the numerator over 10, and say 90% of the universe is duplicates. And that can't possibly be right. And in fact, is not right mathematically, but that's exactly mathematically what they're doing. What this board has always done since it's adopted sampling, back in 1980, is to say, we look inside the sample and then extrapolate out of the sample. We don't look at the sample for the denominator and look at the universe for the numerator, because that would drastically overweight what we would be finding. And again, as we've all acknowledged, we can't change the rules of them.
Yeah, we're at 6:45 currently.
What do we have left here to look at?
Sorry, Chair Housekeep, we do have the 1 hold and the 1 deadlock as well. In addition,
Let's decide on what we're gonna do with those. And we need to decide that quickly here. We've got a hold. Director Bray.
You don't have to decide, because it doesn't really determine the
Or we can
outcome.
leave it either way.
Yeah.
It's not gonna make a difference at the end of the day. There are no more challenges. Is that correct?
There's a 2,
I'm sorry?
the 1 deadlock and the 1 hold.
But none of the.
Those are the two that
Two.
we just mentioned a minute
And we're
ago.
currently at,
So your determination, Senator, but your determination of it is whether it's sufficient or not. You don't have to determine the exact number of valid signatures. We can talk to the, AG's office and make a recommendation for the board going forward as to what these scenarios might entail, but it doesn't affect the sufficiency either way.
I just got hung up on margin of error. Is there any way, when I subtract the 2.5 from 65.7, it does go below the validity level of 63.6.
Not a statistician. We hired a statistician.
Okay.
It was extensively covered. I mean, just briefly, I will say, first of all, the confidence interval and the margin of error are talking about 2 different things.
Right.
But also, I mean, with sampling as discussed, there is always some level of uncertainty when you get close. So the board, in my view, accepted that uncertainty when it adopted random sampling.
The only thing I would note is the validity rate has not been adjusted for what 645 would be.
Yeah, you would subtract it from 64.5 because the number is now 645, which takes you well into the margin of error.
It does.
But what we have said is that we have a validity rate. It's
Mhm.
not, and we determined that it was 636. We didn't say it was 636 plus or minus 25. It's a validity rate. I think that,
Yep.
that you addressed that earlier, that is clear. We don't have a variety of, or, it's not a variety. We don't have a spectrum of validity. We have one. We have to have this many signatures out of the number that have been provided. And that is what we said, and that's what we've got to stick to. We can't, I understand the sort of confusion because I've kind of had it myself, quite frankly, but I have resolved it to my satisfaction that that it is not 636 plus or minus 25. It's 636. And if we have more than that, then I would move to certify.
May we have closing statements?
Say again?
May we have closing statements?
You can chat for a minute, yeah. Is that what you want to do?
Um,
We really have.
We do have to
Maybe
go.
if we need to chat, we need to have public comment.
Yeah,
Yeah, that's exactly what we could do, is we could.
we would just reiterate the confidence.
One way or another, at exactly 4:30, we're going to switch to public comment. But the other one, the reason I'm becoming concerned here is we were supposed to work out wording. And we're going to do public comment before we do wording, and that means we may not get to wording.
Mhm.
So we're really kind of up against the wall here. I don't mean to be grouchy, but.
And wording does not have to happen today. We
Okay.
really wanted to do it today because we have all these folks here. We didn't want to make them make 2 trips, but it doesn't have to. We have more time to do wording. We
Perfect.
have to do public comment.
So you've got 3 minutes.
We just wanted to reiterate that it's not about, close enough is not good enough here. With getting down to that 64.5%, the closer you are to that validity rate or that validity rate, the more likely it is that you are maybe not above the amount that you need to certify. This board needs to be, I don't agree that you can not be confident. Your duty is not be pretty sure that you have more than the constitutional threshold. It's you canvass and you know whether you've reached the requisite number of signatures. I understand the sampling process. We don't believe that MOP has proven to you that they have enough signatures to appear on the ballot. So we ask the board to act consistent with its duties and with the Michigan election law and not certify this petition.
Thank you. Mr. Brady, she had 3 minutes, so you can have 3 minutes too.
Appreciate that. Well, thank you again for the opportunity. It's certainly lived up to its billing, I think. My opponent's July 9th sworn challenge, page 3, says in bold, centered, is bold, number of valid signatures formula result. Next line, 636 or more certify. Next line, 635 or fewer deny certification. That's their sworn challenge. It tracks, of course, with the staff report. It tracks, of course, with the sample that was drawn, put out on June 25th. But happy to end on a unifying note. Drawing back to July 9th document that they wrote, 636 or more certify. With that, I'd like to just address briefly the ballot language. Everyone is here, and ballot language, as you know from prior instances, can be something that might be litigated. And so I would say in the interest of judicial economy and just for everybody, I'll just note, we had no objections. We filed no response to the language put forward by Director Brader, and I didn't see this noted anywhere from my opposing counsel either. There was a deadline for that. Neither of us weighed in. And I think that makes sense because it tracks with the language that's already out there. And while, we know there's an AG opinion, you're allowed to change it. Why would you change it? Why confuse folks? Just like you had the conversation about the State Constitutional Convention and a concern that, the language is different from 16 years ago. This might confuse people. This language is on petitions. We've been going over these petitions today. Why would we change that language? So I just ask that you adopt the ballot language as is.
We're not going to do the ballot language right now. We're going to figure out whether we're going to move forward on the
Understood.
ballot. I have to tell you before we decide to vote, both sides in this issue are so well represented. You five people represent absolutely the finest legal minds in elections in Michigan that I've had the privilege to work with in 5 years. Both sides here are extremely well represented. You've both made great arguments. Now we have to do our job.
Mhm.
And margin of error, no margin of error. You've got a picture today for just how split this is. This is fairly serious. So without more comments from me, does anyone on the board have questions or comments they would like to make?
I think that we have so thoroughly explored all of the signatures which have been in contention and satisfied ourselves that there are more than 636 valid signatures supporting this petition. So I think we have given this really thorough consideration and that we need to entertain a motion.
Cummings? Anything?
Nope.
I do have a question since about whether the change that we have made in the calculation of the number of signatures affects the staff. No, it doesn't. The staff's recommendation is just that we determine that the petition is sufficient. So I think that it's time for us to make that.
Before we vote, I will say that obviously, you know, the numbers is the number, and that is our process. I would say near 40% invalidity rate does not give me great confidence in taking a yes vote today. This was not well done. The number of duplicates, the sloppiness of this can't be disputed. I mean, this is nowhere near giving confidence in this ballot initiative. I really don't have great confidence in taking a yes vote today. I don't. For not only for everything that we just went through today, but for all the additional, as council had brought up, that level of duplicates, just us being able to go through and find these, how close this is, I don't have great confidence taking yes vote today. I understand the number is the number. I understand these are our procedures. But I absolutely do not have great confidence in taking a yes vote on this. I think this was an extremely sloppy process. I think that again, I will leave it at that, but do not have confidence that the actual number of valid signatures that are required were actually met in this case. I understand our process and we have our number, but I do not have the confidence that the number of valid signatures that were required here have actually been met.
Well, we don't need help from the audience right now. Thank you. Yeah, we have a number. The votes, the number is still on the side of approving and accepting the Bureau's recommendation. I have a lot of the same concerns, and I've spent an enormous amount of hours with these petitions. More frustration than anything else. I almost see what you had. You went through a long period of time. You guys got close to the end of the cycle, and you had to generate signatures and a lot of activity. I know my corporate staff does that all the time to me. without having any more conversation, if no one's got anything more to say, I think we have to have a motion and we have to vote.
I move that the Board of State Canvassers accept the staff recommendation and find the petition submitted by Michiganders for money out of politics sufficient.
Second.
Been moved and it's been seconded. All in favor?
Aye.
No.
I didn't get to the note. I have to stay, I have to say I'm going to vote aye with this and, I'm an aye. All right. Now, all in favor, all against? Sorry about that. I didn't give you a chance.
No.
Okay. All right, we're going to move on and we're going to do public comment. Thank you all. Thank you very much.
Thank you.
Right,
Mr. Gallup.
see you again.
Mr. Gallup.
I can't. Oh. Will you do the timer for me?
Yeah, of course.
Mr. Gallen has 1 minute.
A minute?
Okay. Um,
We've got to be out of the room by 5 sharp.
Come
So
back.
If you don't mind.
You want to stick around?
Just let people speak.
Hello, can you hear me now?
Mr. Gallant,
Yes.
hear your voice. You have 1 minute.
Oh, 1 minute. Thank you, sir. James Gallant, Market County Suicide Prevention Coalition. Our concern today is with your decision-making process and your rules of procedure and your contradictions of the fundamental principles of parliamentary law enshrined in part in Robert's Rules of Order as required under the Michigan Constitution. According to Mike Brady, Director of Legal Services for the Michigan Department of State, instructing Secretary Benson and the Michigan Independent Citizen Redistricting Commission in 2020. Page 366, line 8 in Robert's Rules talks about there shall be no debate before there's a motion and a second to approve a specific action. Also, a motion to table is a secondary motion requiring the attachment to a main motion, and compound motions and straw polls are out of order. This board completely contradicted that process in a way that Karl Marx advocated in the Communist Manifesto. Go to America, get appointed to autonomous public office, and contradict the state of being that is there. Your oath of office is under contract law. The chair is to maintain decorum. Statements must be germane to the immediately pending motion. This process is confusing the members, and you can see it in their eyes. And this is what is driving suicide in this state, is people participating here. Yes.
Mr. Gallant, thank you for your comments.
Please give me 1 more minute.
You in August. Thank you, sir. Next item, we're going to try to get through everybody here. I have a Nancy Liskowski. She left? Oh, I'm sorry. All right. We also have Lisa Hirsch. I'm sorry?
She left.
She did. Okay. Good afternoon. Ancella Hardaway. Hardaway.
Overflow. Move on.
Okay. How about Jeff Shaper? Ah, Jeff, I knew you'd be here. Jeff, please, you know the routine. You'll need to turn your mic on too.
Hello, I am Jeff Shaper, Jeff, Shaper, SCHAEP as in Peter, ER. I want to say I'm so impressed with what you did today. It really, your professionalism and dedication by you and the Board of Elections is just amazing. Okay, I had sent a letter earlier to Thursday to all of you expressing concerns about the citizens only voting not being processed yet. And then I got a call from Paul Jacobs and I sent an Amelia Latilia, never mind, email after that. Thank you very much. And I should have taken your advice as keeping with the media, that the big chill, I should have chilled out on that. And I'm able now to be able to tell people it is being processed. They've got the samples and they're working on it. I also want to say I took the county cancer training run by Christine Dugan. It was excellent. I appreciate it. We went to the logic and accuracy testing in Oakland County, and I want to say that I brought some citizens and they watched the process. And the one common comment was, man, that's a lot of paper. So the clerks and everything like that, we're appreciative because now they get to explain the process and people now understand what logic and accuracy testing is about. So that's all the good stuff. As you know, politics, the old saying is, "Oop, am I a minute up?" All right.
Now,
Well, thank
before
you all
go,
very
You
much.
know, as long as you're here and as long as you were commenting on the other petition that you sent me correspondence about, I would invite you on the record to tell these folks at the end of the table what a fabulous job they're doing working all these extra hours to get that petition done.
Yes, you are doing a fabulous job working the hours, and I can see now with the challenges and things like that, what you have to look at. Thank you. We all thank you. And we'll be seeing you August 24th.
Thank you, sir. Is Lisa here yet? Lisa, did she leave? Okay. That is the end of the public comment. Well, wait a sec. Hold your horses here. What do we got?
So, yeah, sorry to interrupt. So the motion on the number designation is pretty straightforward. We can do that. The wording, we really don't have very much time. If everyone agrees with my wording, that is phenomenal and we can just go ahead with it. But if there's going to be any substantive discussion, we don't really have time. So that's really up to the board. But I guess the attorney's left, so I don't know.
I
But
think the wording has to, Mr. Doster left and I know that he had asked to speak on the wording.
Okay,
Um,
okay. I think, well, since we're doing the wording later, does it make sense to do the number designation now or just hold on that? Okay, I guess we might as well do the number designation since we're all here, if that's okay with you.
We can do that.
Okay, so long story short, the numbering is gonna depend on, because of the order that they were submitted. So even though the deadline for processing the Michigan Money Politics petition was earlier because of the legislative deadline. So even though the board approved the sufficiency earlier, because American Citizens Voting, Americans for Citizen Voting was filed earlier, that gets an earlier number if it gets sufficient signatures. So in other words, if and it's also obviously we have litigation. The legislature has the opportunity to weigh in on the Michigan Money Out of Politics proposal. So we still don't really know whether either one of these is going to be on the ballot for sure. But essentially, if both Michigan Money Out of Politics and Americans for Citizens Voting both are on the ballot, then Michigan Money Out of Politics will be 2026-3. And if only Michigan Money Out of Politics is on and Americans for Citizen Voting is not, it will be 2026-2. So this is essentially a conditional motion to give it the whatever number is appropriate based on the circumstances.
I move that the Board of State Canvassers designate the initiative petition submitted by Michigan for Money Out of Politics as proposal 2026-02 or 2026-03 on the November 3rd, 2026 general election ballot with the proposal number depending on the sufficiency determined of Americans for Citizen Voting.
Second. All in favor?
Aye.
Aye. All right. We've agreed we're gonna hold off on the wording.
When does the wording need to be determined? Is just before the ballot?
Yeah, I mean, it'd be 60 days. So the legislature now has, well, depending on what happens with litigation, but this now transmits it to the legislature. The legislature has 40 days to act on it. If they don't, then it goes on the ballot. So that's really the time at which the wording would be needed. We were, again, just going to do it now because of obviously all the folks here, the attorneys, everyone else. We're trying to not make them make 2 trips, but that's what we'll have to do.
Okay.
That being said, I did think the wording was.
Thank you.
I agree. I don't know if we're,
You got 2 of you.
that's how it usually goes.
I feel like we had a request from the other attorneys to be part of that discussion.
We don't need to hear from
Right.
him, from,
Yeah.
are you talking about Doster?
Yeah, there you go. Yeah, yeah.
Let's, we have, come on, look what we have here.
Yeah, the only thing I'll just note since we're before is so the wording is not exactly the same as the initiative petition because it cannot be. So it does need to be phrased slightly differently on the ballot because it has to be phrased as a yes or no question should this proposal be adopted. Also, those words count towards the 100 words. So to get those words in, I did have to move some words out of the initiative petition summary. We also have the caption, which does not count towards the word limit, although there is some practical limit because it has to fit on the ballot and we're not going to put like a 20-line caption on there. But with all those adjustments, essentially, I tried to keep the wording as the same as possible while making a couple of those formatting changes. So when we consider it later, that's just where that was coming from.
Okay, so is there any other business to present to the board? No
We've
one?
got 20 minutes.
I know we do. We're getting done early. There is one item I wanted to just make sure it's on record. It was on the public comment, but the other petition, the Americans for Citizen Voting, I've had a lot of emails of people wondering where we stand on that. Director Brader.
So the universe of all the sheets was released earlier this week to FOIA requesters, and today the sample, the 1,000 signature sample was released. So those are now available to FOIA requesters who have paid for them. As with the one we just did, we still need to pull the paper sheets. So, that's going to take some time. And I imagine people want to look at those just as they did with this one. But the sample with all the signature sheets is available. So we've begun processing that. Challengers will have the opportunity to respond to that. We'll have a staff report out at least 7 days before the August 24th meeting, and the board will consider the sufficiency of that on August 24th.
Perfect. And with that, I hope you're all registered to vote, and I hope you all vote on August 4th. And thank you for your patience today. The meeting is adjourned.